court. My learned friend, Ms. Engelbrecht, and I appear for the applicant.
Thank you, Mr. Trengov.
May it please you, Chief Justice, I appear together with Mr. Quinn and Ms. Charlie for the Competition Commission.
Thank you very much, Mr. Ngaitobi. Thank you. We apologize for the delay that has happened before we could start. As I indicated, there have been some IT challenges, but I think we should then start immediately. I will keep an eye on the time because we don't have the time available that we have at cost. I might indicate some stage where maybe when it's 5 minutes left, but I just ask counsel to keep an eye on the time on their own as well. Thank you, Mr. Trengov. Your 30 minutes starts now.
Thank you, Chief Justice. I propose to address 3 topics. First is the facts. Secondly, the standard of review. And then thirdly, the issue of causation. There are other issues, but they are addressed in our heads of argument, and I don't propose to elaborate on them unless the court has questions on them. I start with the facts because it is the one topic on which we do wish to add to what we've said in our heads of argument, particularly in the light of the 20-odd pages not previously part of the record, and in response to our learned heads of argument. And let me say on the facts, the first submission we make, which we submit as fundamental, is that it is clear that the Commission's original letter of apparent transgression was based on a mistaken recollection or impression of its own findings that it had originally made in the investigation of the merger. And that mistake has permeated the Commission's position and is persisted with even in the papers before the court. And to understand the significance of the mistake, let me just take a step back and say something on what the papers show about the business model of Coca-Cola in South Africa. The essential feature is that Coca-Cola divided the country into 5 regions and appointed a distributor in each of the 5 regions. And it has contracts with each of them, in terms of which each bottler enjoys exclusivity within its own region to bottle and distribute Coke product. Those bottlers, the 5 bottlers, in turn have bottling plants dispersed throughout their region, more than one per region, and there are indeed a number of them. What then happened with the merger is that 4 of the 5 bottlers participated in the merger. Only the 5th, the Western Cape regional bottler, was left out of the merger. And what the merging parties told the Commission, and it accepted and reported, was that they did not expect any duplications to arise as a result of the merger in the bottling plants, because the bottling plants would remain in full operation and there would be no duplication. And that's significant because it is in the bottling plants where the employees who constitute the bargaining unit are employed. So no redundancies were expected in that category of employee in the bottling plants. The duplications were to occur at the managerial and administrative level because the 4 merging parties had 6 administrative head offices throughout the country. And the merging parties made it clear that they proposed to consolidate those 6 offices into one national administrative head office, that would lead to duplications and retrenchments. And indeed, those retrenchments were foreseen and permitted significantly, though, that they fall outside of the bargaining unit. And that was then the origin of the original conditions laid down for the merger, namely that a limited number of retrenchments were allowed of employees outside of the bargaining unit, but no retrenchments were allowed of employees in the bargaining unit, that is, in the bottling plants, caused by the merger. And then what is important is that the Commission's report recognized that there were, and accepted, that there were duplications expected in the administrative and managerial level, but not at the bottling plant level. And what is important is to have a look at the Commission's own report on that issue, because that is the report which they later, 3 years later, misunderstood when they characterized the most recent retrenchments. And we have submitted a list of references, which I am told has been distributed to all the judges, merely to facilitate the references to the record. And I have been informed that the judges all have the list. So I would not go to all of the places in the record on which we rely on the list, but I would go to just a few of the most important parts of the record. And that is firstly, extracts from the Commission's merger report of the 11th of December 2015. That's the Commission's merger report preceding the first merger. The report itself is in volume 3 at page 276. Now, this is the report which the Commission later misunderstood. And you will see that in our list, we list some 6 references to the report, all of which really say one thing, and that is that there are bottling plants all over the country. We don't expect any duplications to arise there, but we do expect duplications to arise at the managerial administrative level, and therefore retrenchments will occur at that level, but not at bargaining unit level. The most important extracts are firstly the one mentioned in our list in paragraph 1.2, that's volume 3, page 288, paragraph 31. And if I may just go to it, it says, the merging parties estimate that there will be 250 merger-specific job losses at executive, managerial, administrative, and technical level. The parties have reduced the number of job losses from 387 to 250, as was initially submitted. The merging parties will be closing about 6 separate offices, where only one office is required after the merger. They anticipate that there will be no involuntary retrenchments among the employees who form part of the bargaining unit. That's the important sentence. No redundancies were expected, no retrenchments were expected at the bargaining unit level, that is in the bottling plants. And then to the same effect, our reference in our paragraph 1.5, that's at page 295 of the report. And this one is particularly important because when the Commission later misunderstood its own report, it referred back to this reference. It's page 295, paragraph 374 and 375. You'll see that in 374, there is a table, table 22, and it says number of employees employed by the merging parties. And then there's a list of job categories and numbers employed. But the important thing is to say that that was merely total numbers. That said nothing about expected duplications or redundancies. And paragraph 375 is then the important one, which explains what was expected. It said at about 2,688 of the 7,549 employees employed by the merging parties on non-bargaining unit employees. The remaining 4,861 employees fall within the bargaining unit. And then the important part. The merging parties have indicated that the implementation of the proposed transaction will result in the duplication of about 387 positions, non-bargaining unit employees, at an executive, managerial, administrative, and technical level. So the report made it clear that the merging parties said, and the Commission accepted, that duplications would occur at the managerial, administrative level outside of the bargaining unit, but not at plant level in the bargaining unit. And in our list, we then also refer to the references in the applicant's founding affidavit, where the same thing is said. It simply repeats that that was expected, and that is what happened. The bottling plants, all of the bottling plants continued in full production, and there's been no redundancies caused by the merger in those bottling plants. And then came the Commission's mistake, because 3 years later, 3 years after the original report, the applicant reported that it proposed to retrench workers from some of those bottling plants from inside the bargaining unit, which it said was not caused by the merger. But the Commission then misunderstood its earlier report. And what the Commission's first reaction was to say, yes, but in our original investigation report, we contemplated duplications in the bottling plants, and that is now what's happened. And therefore, this is a retrenchment caused by the merger. And the error is firstly made. In fact, it was not first time in time, but most significantly made in the Commission's apparent breach letter. And that letter we itemize in our item 4.1. That's a letter of the 24th of October 2018, in which the Commission notified my attorneys of their finding of an apparent breach. And this is what they say in paragraph 2 of the letter. That's on volume 2, page 122, paragraph 2. After an extensive investigation, the Competition Commission found, now they refer back to their original merger investigation. Competition Commission found that the involuntary retrenchments of the affected employees by the merged entity is merger specific. This is because the affected employees were employed at the merged entity's bottling operations, and then the important part, which operations the merged entity indicated it wished to rationalize in order to reduce duplications and staff costs. Here they confuse the bargaining unit employees in the bottling plants and the managerial and administrative employees not in the bargaining unit. They make the same mistake 4 times in all. In fact, before the letter was sent, there was the Commission's minute of the 30th of August, which is at page 300, volume 4, page 370. It's a meeting of the committee which preceded the issue of its apparent breach letter. It was dated the 30th of August 2019, and the significant paragraphs are at 373, paragraphs 11.3 and 11.4. And this is particularly important because they refer back to the table 22 to which I had taken you in their investigation report. They said in paragraph 11.3, the team notes that the retrenchments are taking place in the bottling operations of the merged entity mentioned above. These are the same roles where duplications occurred as a result of the merger, and this is what the conditions aim to avoid. Below is a table from the Commission's merger report in relation to the merger, indicating the roles where duplications would occur as a result of the merger. And there is then the same table 22 to which I previously taken you, which you will remember from the previous report was not a table showing duplications at all. It was merely a table showing total number of employees. And it was followed by a paragraph which specifically said, but the duplications will occur only at the managerial level outside of the bargaining unit. And the Commission goes on to say in paragraph 11.4, from the above table, the team notes that the merger resulted in duplications of roles, but the roles which had a high number of duplications were roles such as manufacturing, logistics, etc. So what they now do is to interpret that table as a table reflecting duplications, and moreover, duplications in the bottling plants, whereas the table in its original report was simply a table of the total number of employees, followed by a paragraph which said, we expect duplications at managerial level and not at bottling plant level. And then the same mistake is made again in the Commission's memo of 17 April at page 400, more particularly at 401, paragraph 7, where they said the team's investigation found that the retrenchments were merger specific. And this, they now again confusing the two, because merger specific, as they occurred in the areas of duplication arising from the merger, i.e. bottling operations, and all the affected employees were members of the collective bargaining unit. And then even in the Commission's answering affidavit in this case, they perpetuate the same error. We give the reference there at page 227. May I just ask you to correct a paragraph number? It is paragraph not 3.2.2, but 30.2.2. And that's a paragraph in which the Commission says in this litigation, the retrenchments of those employees were from the bottling operations of the merged entity, where the duplications occurred as a result of the merger. In the merger report, this is their own earlier report, the merging parties, including CCBA, produced a table indicating where duplications would occur as a result of the merger. While the 2016 merger resulted in a duplication of roles, most of the duplications occurred in, and they say, within the bargaining unit. And then secondly, the same error in paragraph 31, where they say, in conclusion, it is clear that CCBA is in breach of clause 9.2 because the retrenchments were in areas that were identified to result in duplications during the merger investigations. So the entire case of the Commission is built on a mistake, and it's a mistaken reading of its own merger investigation report. And that mistake has never been cured, and it's still part of its case. We submit that with respect to that mistake is fundamental because it is based on a demonstrably misunderstanding of their own earlier report. So where does it leave one on the merits of this case? In other words, on the question whether CCBA is in fact in breach of the ban on retrenchments as a result of the merger or not. The starting point is to recognize that the Commission's letter and its position is based on a misunderstanding. One is then left with Coke's own explanation for the most recent retrenchments, and it says that there are three reasons for them. Firstly, a general downturn in the economy. Secondly, a new sugar tax, which cost it dearly. Said for the first 9 months of the tax, it costed 2.1 billion rands. And then thirdly, significant increases in the sugar price. And those factors combined led to a downturn in the demand for its product, as a result of which it employed a package of cost-saving measures, of which retrenchment was one. Now, there was some controversy about the retrenchment, but let me just make it quite clear that the controversy about it is not a controversy relevant to the debate before this court, because that's a controversy on the question whether the retrenchments were operationally justified or not. And there was a complaint made by the union, but it did not pursue that complaint. But I just want to emphasize that one shouldn't let this debate in this court be obscured by that debate, because that debate is not, the only debate relevant before this court is whether the retrenchments were caused by the merger. And that debate is unaffected by the side debate about whether the retrenchments were justified at all or not. So submit with respect that the Commission's case is based on a misunderstanding. The Coca explains that the retrenchments were part of a package to reduce costs, to meet unfavorable trading conditions. And the Commission doesn't really respond to that explanation. What the Commission says is, well, it can't be true because you still made a profit. But that, with respect, is a non sequitur. Their profit was down, and businesses seek to maximize their profit. So simply to say to them, all of this is untrue because you still made a profit, is not an answer at all. It was a cost-saving measure employed by the merged entity to meet the exigencies of changed economic business circumstances, and was therefore not merger specific. May I then turn to the second topic, and that is the question of the standard of review. And there's a great deal of debate about it. And let me confess, my side has been equally guilty of obscuring what we submit today as the true interpretation of the rule, and therefore the true standard of review. So we're not placing blame on anybody else. It has been a long road to come to what we believe is the proper interpretation of the section of the rule. And that, with respect, is, in our submission, simply to say that the rule means what it says, nothing more and nothing less. That Rule 39 says that when a merged entity receives a notice of apparent breach, it may do one of two things. It may submit a settlement proposal, basically, or under 39(2)(b), it may request the Competition Tribunal, and here are the important words, to review the notice of apparent breach on the grounds that the firm has substantially complied with its obligations with respect to the approval or conditional approval. So we submit that that is all there is to it, is that the tribunal must inquire into and determine whether the merged entity has substantially complied with its obligations. And it is a review merely in the sense that it is a consideration of whether the Commission has substantially complied or not. And we submit that straightforward interpretation, uncomplicated by further elements of administrative law review, actually makes good sense, because in the first step, the Commission acts on mere appearances. The Commission doesn't make a finding of fact. The Commission reports merely that the merged entity is guilty of an apparent breach. In other words, on the face of it, a prima facie suspicion. And that is all there is. It reports a suspicion to the tribunal. The tribunal doesn't inquire into the question whether the Commission's suspicion is justified, because that would be irrelevant and unhelpful. What the rule requires the Commission to do is then to determine whether the firm has substantially complied. So its purpose is merely to give a suspect firm an opportunity to come forward to demonstrate that the Commission's suspicion is unfounded because it has substantially complied. If it succeeds in showing that it has substantially complied, then it's off the hook. If it fails to show that it has substantially complied, well, then it's open to the Commission to take all sorts of further steps against the merged entity for breaches of the merger conditions, if any. And indeed, you will see that both the tribunal as well as the Competition Appeal Court accepted that the real inquiry before the tribunal is and should be whether the merged entity has substantially complied with its obligations. Both of them then complicated it by suggesting that there may be more to such a review, that there may also be an inquiry into the question whether the Commission acted fairly, rationally, and reasonably. But we submit with respect that that is an unnecessary complication, and there's nothing in the rule to suggest that it's justified at all, and nothing in common sense to suggest that it is helpful. The Commission is justifiably critical of us for shifting ground on what we say the standard of review is. But the Commission itself doesn't give us an answer. There's no competing answer before you. And in fact, the Commission criticizes our submission today in its heads of argument on unjustified grounds. It criticizes us in paragraph 100 of their heads of argument by saying the following: CCBA's interpretation is also senseless and wasteless from a practical perspective. On CCBA's construction, the process operates thus. The Commission asks and answers whether there has been a breach of the merger condition. Well, that's wrong. It doesn't ask whether there's been a breach. It asks whether there's been an apparent breach. That is as far as it goes. And then they go on. They say a dissatisfied firm then goes to the tribunal, which must ask and answer the exact same question. Not so, not the exact same question. The tribunal doesn't ask itself whether there's been an apparent breach. It asks itself whether the merged entity has substantially complied. It's a different question. And then the Commission adds that interpretation with respect makes no sense. They say, in doing so, the tribunal cannot look at what the Commission did and why it did it. That's unfounded. It can look at all the evidence and certainly look at why the Commission suspects transgression. There's no consideration excluded from the inquiry, but the purpose of the inquiry is not to determine whether the Commission was right. The purpose of the inquiry is to determine whether the suspicion is justified, or in the rule's words, whether the firm has substantially complied. So we submit with respect that the Commission's interpretation, I'm not sure what the Commission's interpretation is, but submit that there is, in fact, no other defensible standard of review than that the tribunal simply has to determine whether the firm has substantially complied. Then there's the issue of causation. And it seems to us that the causation issue has been unduly and unnecessarily complicated in this inquiry, because the rules...
you have 6 minutes left, Mr. Chengo.
Thank you,
You have
Chief
6 minutes left. Okay.
Thank you very much. The merger condition that we're concerned with merely says that Coke may not retrench bargaining unit employees, quote, as a result of the merger. And now that is straightforward South African causation speak. There's nothing complicated about it. You must see whether the merger caused retrenchment of the bargaining unit employees. And one is faced with a very mundane, ordinary question of causation. One gets the impression from both the tribunal and the Competition Appeal Court that this because a later rule speaks of retrenchments which are merger specific, that somehow is a term of art with a different meaning. But with respect, firstly, that is merely used in a later rule which describes what is permitted. So that retrenchments are permitted provided they're not merger specific. But the rule we're concerned with is even simpler than that. The condition simply says you may not retrench bargaining unit employees as a result of the merger. It's a mundane causation test. The question then is, what test should one apply? Oh, and let me also just say this. Merger specific is merely competition speak for caused by the merger. There's no magic to it. It doesn't mean anything other than caused by the merger. The question then is, what is the test for causation that should be applied? And of course, causation can have subtle variances of meaning. For instance, in the law of delict, where one has sine qua non plus a requirement of legal causation. We speak of the insurance world, where causation requires a more immediate link between cause and effect. Justice Majid, in his judgment in this court, in the Aveng case, spoke of the true reason for the dismissal. We would submit that in this case, that probably best captures the requirement of this condition as a result of the dismissal. In other words, one should ask yourself whether it is the true reason for the dismissal, whether the merger is the true reason for the dismissal. But let me say this. The subtleties of the different possible tests for causation should not make a difference in this case, because we submit that there isn't even sine qua non. There's not even but for causation. You can't say that the merger caused the retrenchments, because there is simply no reason to suppose that if the merger hadn't happened, the retrenchments wouldn't have followed. The same economic circumstances would have prevailed, and the same incentives would have been there to retrench in order to save costs. So we submit with respect that whatever the subtleties of different tests for causation, the fundamental requirement of a sine qua non causation has not been met and is therefore not satisfied. Chief Justice, I'm done. I think I'm within my 30 minutes.
Thank you very much. Actually, I gave you, I think, about 5 extra minutes by mistake. On my watch, you had started at 11:25, but as time went on, I thought you were going to finish, 10:25. You had started. As the time went on, I thought you would finish at 11 instead of 5 to 11. So, but I will make sure that Mr. Muratobi also gets the same. Thank you very much.
Thank you, Chief Justice.
Thank you. Well, you would have seen that counsel for the commission takes the point that this issue about whether the retrenchments were as a result of the merger is a factual issue, and therefore submitting that the court doesn't have jurisdiction. Do you want to say anything about that?
Chief Justice, yes, there is ultimately a factual question, but there is also a debate as to what the right question is that needs to be asked. And there is a debate about the proper standard of review under Rule 39, under Rule 32B. And that debate is a debate that engages constitutional values, fair labor practices, the right to trade, and also administrative law. So there's a range of constitutional values engaged in the prior inquiry, namely, what is the right factual question to ask? So that to respect there is a factual dispute, but founded upon a debate which engages constitutional values.
Yeah. Thank you. I'm looking at my colleagues to see if there are indications of questions.
CJ?
Yes, Justice Mhlanhla.
Thank you, CJ. Good morning, Mr. Trendorf.
Good morning, Justice.
I'm sorry, Justice Mhlanhla. I'm sorry to disturb you. I was informed earlier on that Justice Matopo's picture wasn't there, but I see he has just emerged. So, okay, all right. Justice Mhlanhla, please continue.
Thank you, CJ. I just need you to take me through the steps when a notice of apparent breach is sent. My understanding from the papers is that there's a complaint that was lodged by the union, and the commission then wrote to the firm concerned, and the firm then responded to the commission. At some stage, there was not an agreement between the two parties, and that ultimately resulted in the notice of apparent breach being issued, which was sometime in 2019. Now, that notice, is there any decision that is made by the commission, bearing in mind that it had received some communication from the firm? I'm trying to link this to what we normally know in a review matter. There will be a decision that is going to be reviewed. Is there any decision made by the commission that will end up being reviewed by the tribunal? Or if not, what actually transpired under these circumstances?
Mhlanhla, thank you for that question. It's an important question, and because the Commission overlooks it, and that is that under Rule 39(2)(b), the Commission doesn't decide anything. The Commission merely, sorry, not 2b, under 39(1), the Commission doesn't decide anything. It says, the rule reads, if a firm appears to have breached an obligation that was part of an approval or conditional approval of the merger, the Commission must deliver to that firm a notice of apparent breach. So the Commission acts on appearances. It makes an inquiry. It might be more or less thorough, but it ultimately issues the notice if it appears that the merged firm has breached an obligation. So it doesn't decide anything. It doesn't affect anybody's rights. It has no consequences at all. It merely triggers the process under 39(2), so that we submit with respect that there is no decision up for review in the way that we would normally think of an administrative decision which has legal effect.
And the firm then has two options, either to go along with the respond to the commission or run to the tribunal to say, I've complied, make a ruling.
Yes, the firm, and effectively, what it really, I think, boils down to is to say the firm can plead guilty and settle the case, or it can go to the tribunal and say, let me show you that I have, and to pick up the language, I have substantially complied with my obligations. Please exonerate me.
Okay. Now, ordinarily, the commission would have been the one that would have actually submitted a case to the tribunal, and the firm would be the one that's defending. So under Rule 39, it's a different scenario.
Indeed. And let me say, if I think properly characterized, what the rule does is to say to a merged firm who is under suspicion of breach, to give them an opportunity either to settle or to prove their innocence. Because if they succeed, then that's the end of the matter. It's a quick, practical procedure which allows the firm either to settle or to demonstrate its innocence. If it fails to do so, nothing follows from its failure other than that it opens the door for the Commission to then take further steps against it. But those further steps are independent of the outcome of the Rule 39 procedure.
Okay. Thank you.
Justice Johnson. I thought you had your hand up earlier.
I'm afraid I can't hear you, Justice.
You may be muted, Justice Johnson. We can't
can you
hear
hear me now?
you.
I can hear you now.
Now we can hear.
Thank you, Chief Justice. Mr. Tringove, if you wouldn't mind having a look at your copy of the Competition Act. My question to you, and it's effectively also directed to Mr. Nkunkai, is whether we are looking at the right place when we look for a source in the statute for the rule. The consensus to date seems to have been that we look to Section 27(1)(c). My question is, do we not in fact look to Section 27(1)(b)? And you will see that Section 27(1)(b) says the Competition Tribunal may adjudicate on any other matter that may, in terms of this Act, be considered by it and make any order provided for in this Act. And if one then looks back to Sections 15 and 16, one sees that there are very specific provisions pertaining to both the Competition Commission and the Tribunal in relation to breaches of merger conditions. So for the Tribunal, it's Section 16(3), subsection 3, deals with or gives the power to the Competition Tribunal to revoke its own decision to approve effectively if there's been a breach of a merger. And it incorporates by reference Section 15, which is the provision that governs the Commission. If one looks at 15(1)(c), it specifically provides for the scenario where the Competition Commission may revoke its own decision, C, where a firm concerned has breached an obligation attached to the decision. So my question is, are we not simply faced with the situation where a rule has been made and the rulemaking power seems to provide specifically for this scenario? If we have a look at 21(4)(h), 21(4)(h) says the Minister, in consultation with the Commissioner and by notice in the Gazette, may prescribe regulations for matters relating to the functions of the Commission, including, there are various things listed there, and H is procedures. And in fact, if one looks at the Commission rules, that's where the rules come from. That's what the Minister refers to as the source of his authority. So all of that to come back to my original question, are we not barking up the wrong tree if we're looking at 27(1)(c)? Is it not in fact 27(1)(b)? It's a regulation to provide for a power that's expressly given to the Competition Tribunal in the statute.
Yes, I submit with respect that your analysis is quite correct, and that the immediate answer to the question is that the review is one created by and regulated by the Rule 39(2)(b), a rule which is authorized under the empowering provision which you have identified. I must just make it clear, though, that the processes under sections 15 and 16, these are for punitive steps against a merged entity which has breached its merger conditions. These are procedures that follow further down the line. The process we're concerned with is one which is designed to head off those processes under 15 and 16 and 59. Those are all punitive steps that may be taken against a firm that is breached, but they kick in only if there is under the rule we've now been looking at, only if there is a notice of apparent breach, the merged firm goes to the tribunal, but fails in persuading the tribunal that it has substantially complied. Then it opens the door for the Commission to proceed under sections 15, 16, 59, and so on. So I do agree with respect that you are correct in identifying the source of the power. But ultimately, the review is governed by the rule and not by anything beyond it.
I understand from your argument that you would agree with me that one cannot say that the decision of the Commission to issue a notice of apparent breach would amount to administrative action under PAJA.
No, it's a notice that expresses a suspicion, and it has no legal consequences at all. It is merely a trigger for the process which has been created under Rule 39, designed to head off serious prosecutions for breaches of merger conditions.
And then my final question to you is, in the application for leave to appeal to this court, your client concedes that it bears the onus in the proceedings under the rule. Is that a concession that you stand by and that you say was correctly made?
I do so with a heavy heart, but I do so, yes. It seems to me that it is for the accused under the rule to demonstrate that he has substantially complied. And if you can't demonstrate that, then the Commission says you haven't succeeded in your application, and that opens the door to the Commission to proceed against it.
Thank you. Thank you, Chief Justice.
Thank you. Justice Keepers. Justice Keepers.
Thank you, Chief Justice.
Go ahead. Can you hear me?
Yes, I can hear you. Thank you, Chief Justice. Mr. Trengove, just on the point that you've been debating with my colleague, Justice Dodson, I'm not sure that the decision, and I'd like to hear you on this, I'm not sure that the decision under 39(2)B is in fact, it does not in fact constitute administrative action. And I'd like to hear you on that, because I think the source of the power and the point to start with seems to me to be Section 27(1)(c), which gives the tribunal the power to hear any appeal or review from a decision of the Competition Commission. Now, that seems to me to be the starting point. And by way of an example, if, for example, the Commission issues a notice to a firm, purportedly in terms of Rule 39(2)B, but there has been no merger at all, that decision surely would be reviewable under the principle of legality, would it not? That's the first question, which suggests that it's not something of no consequence. The second question I have on this point is this, Mr. Trengove. Does that decision under 39(2)B, the notice, what, for want of a better term, the decision that there was an apparent breach, fall under the definition of administrative action under PAJA? Thank you.
You at one point spoke of a decision under 39(2)B. That's the tribunal's decision, and I take it that wasn't intended. Your question is
sorry,
to the Commission's decision to issue a notice of apparent breach.
Correct.
I submit with respect two things. Firstly, that it doesn't constitute administrative action because it doesn't affect anybody. It has no legal effect, and even if it were to be ignored, would not have any legal effect, because it's not a notice not a notice that has any effect on people's rights at all. But let me also say this. And secondly, it for that reason also doesn't qualify as administrative action under PAJA, because the definition of administrative action under PAJA is a decision that affects, has a legal effect. But let me say this, that inquiry is, with respect, an unnecessary inquiry, because we are not here to determine whether there might be some other administrative law standard of review applicable to this rule. The rule itself tells us what the standard of review is. It says that the Commission reviews the notice of apparent breach on the ground that the firm has substantially complied. So it is not necessary for us to do a deep diagnosis of the nature of the decision in order to find the standard of review, because the standard of review is spelled out. And frankly, it's more fundamental than that. I call it the standard of review, which makes it sound very legalistic. But the section spells out what the tribunal must do, and that is to inquire and determine whether there has been substantial compliance. That's the beginning and end. And it would not be justified to read other more complicated standards of review into a rule which is so simple.
Yeah,
What happens?
Not so much.
I mean, sorry, Justice.
Please go ahead. Please go ahead.
What happens, for instance, if you assume some sort of standard of review of the Commission's notice? What happens if you find that the Commission acted irrationally, but at the same time find that the firm is guilty of breach of the merger conditions? What is then the outcome of the process? We submit that the outcome of the process should depend on whether the tribunal finds that the firm has substantially complied, and not on whether the Commission did its job properly.
I'm not suggesting that, you know, there's an additional standard of the Section 33 standard of lawfulness, procedural fairness, or reasonableness. I'm just wondering whether, you know, in my example where you have a notice issued, but there's no basis for that notice at all, in fact, no merger, what would be the nature of, would a party be able to review that decision, for want of a better term?
No, I understand that. And I think, you know, because we require all exercise of public power to be rational, there may well be an argument for a review, but it will not be a review under Rule 39.2. It will be a common law review of the unlawful exercise of public power, and that will probably still be a review before the tribunal, but under Section 27, not under Rule 39.2.
Yes. Thank you, Mr. Tringo.
Justice Rogers.
Mr. Trengove, I don't want to get involved in a sterile debate about the reviewability of the notice of apparent breach. It does seem to me that although it doesn't finally determine the question whether the party has or has not complied with the merger conditions, it has certain legal consequences, among which is it opens the gateway to the Commission to bring an application to the tribunal for revocation or for penalties if the firm has not responded appropriately to the notice of apparent breach. But what I would like to ask you about, and of course your client did, it did seem to in its notice of motion put up two forms of review. It sought a ruling under 39.2b that it had substantially complied, and it also sought the review in setting aside of the notice of apparent breach. But I gather you're prepared to focus the case simply on the point of substance, the 39.2b inquiry. If I'm just having a look at the further provisions of Rule 39.2, or of Rule 39, it gives the firm two options. It can, as you say, effectively capitulate and put up a remedial plan, or it can take the initiative to have its to get a declaration of innocence. But of course, it might do neither of those things. Rule 39.3 tells us what happens if a plan is submitted, and Ford still deals with the plan. Sorry, my computer's just jumped ahead here. Just give me one moment, I apologize. And then it says under Rule 39.5, the Commission may act in terms of Section 15 to revoke, or in terms of Section 5960, that would be to approach the tribunal for some form of penalty, only if the firm concerned does not respond to a notice of apparent breach within 10 days. So if the firm does nothing and the commission then applies directly to the tribunal, there's nothing I can see in the Act or the rules which would say the firm's failure to respond means that the case of a breach is established. I presume then on notice of motion to the tribunal, the commission would say the firm breached, and the firm could oppose it by saying we didn't.
Yes, indeed. There's nothing, the outcome of the 39-2 process, whether a non-event or a finding, does not in any way affect the subsequent steps which the commission may take under those punitive provisions.
Well, that may not be entirely correct. If the firm has chosen to take the initiative under 39-2B and the tribunal makes a positive finding that it didn't comply substantially with the condition, then absent of that being overruled by the Competition Appeal Court, that would seem to me to determine the breach. And then the firm could apply, the commission could then apply for some or other remedy flowing from that. It couldn't be expected that there would be two separate adjudications with potentially different outcomes on the merits.
Oh no, with respect not. The 39-2B process is a process which permits the firm to demonstrate its innocence. And if it succeeds in doing so, it's let off the hook. But if it fails to demonstrate its innocence, it doesn't follow that it's guilty. And it simply means that the procedural bar under 39-2 is then removed, and it's open to the commission to take proceedings against it under those punitive provisions. And there the commission bears an onus of proof. And indeed, the requirements for a fair process would mean that the commission would have to formulate a case which would then be open to the firm to oppose, and the commission would bear the onus, would have to follow a fair process and would bear the onus of proof at the end of the day.
What then, in your view, is the value of the firm taking the initiative under 39-2B, because I gather you accept it bears the onus if that's the route it follows. If it wants to get off the hook at that point, it bears the onus.
Yes.
But whether or not it does that, the commission, if it wants to take further action, still has to approach the tribunal, and it then has the onus on the same question.
Yes, I submit that the purpose of 39-2 is a pragmatic arrangement which gives the suspect firm an opportunity to demonstrate its innocence and be left off the hook. And that is why there's no case formulated against it. There's an onus imposed on it. It has positively to show its innocence. But if it succeeds, then it's let off the hook. If it fails, well, then the ordinary rules must take their course. Commission must formulate a case. There must be a fair hearing. It bears the onus of proof, and so on.
To come back to the standard of review in the broad sense of in 39-2B, if it was a review in the technical sense, then of course everybody would be bound by whatever material was before the commission when it issued its notice of apparent breach.
Well, insofar as reasonableness is the standard, yes, but this court has held that rationality is an objective standard which may be judged objectively, and I don't think that that necessarily confines one to the material before the commission. But let me just say, I mean, this process doesn't even allow for the commission to explain itself, never mind disclose its information. So,
would then seem on your argument that the review, or effectively taking under reconsideration, potentially based on additional and new evidence, is the third category of review which NSCJ had in mind in the Johannesburg consolidated case. He said there are a number of statutes and rules where review is not used in a technical sense, but in a practically, in a sense, of a fresh decision based on further evidence?
Yes, let me say it's a variant of that third category. I would prefer the Hoekstra characterization of simply a special form of statutory review, which can take any number of forms. But this is not even a rehearing of the Commission's decision, because the Commission hasn't taken a decision. So this is a fresh inquiry into a fresh question, not whether there is reason to suspect that the firm has breached, but whether the firm has actually breached. That's the issue before the tribunal.
Yes, thank you, Chief Justice.
Thank you. Justice Chaskalson.
Mr. Tringo, I don't want to... Chief Justice, can you hear me?
I can hear you, yeah.
Yes, I can hear you. Thank you.
Thank you, Chief Justice. Mr. Tringo, I want to engage you on the facts, and in particular the intersection of the retrenchment decision and the harmonization obligation. As I understand the merger conditions, the harmonization obligation meant that everyone in the bargaining unit within particular job categories had to be bumped up to the terms and conditions that ABI employees in corresponding positions occupied or were entitled to. That process had to be complete by May 2020. So come May 2020, there would be a much higher salary bill at divisions other than ABI, because workers in particular job categories would now be entitled to increases to match the ABI conditions of employment. Now, if I understand the FAWU complaint, what FAWU is essentially alleging is that the retrenchments were designed in part to get around the harmonization obligation. By retrenching workers from existing positions and re-employing them in slightly modified roles, where they would do essentially the same work, but because the roles were slightly modified, they wouldn't be they wouldn't be entitled to the harmonization rights. That's essentially what FAWU says at volume 2, page 174, paragraph 8.4. And I read your client's reply essentially to admit that. If you go to volume 3, page 264, 17.1. Now, if my reading of the facts is correct, wouldn't that mean that the retrenchments are at least in part retrenchments as a result of the merger? Because they're retrenchments that are designed in part to get around a harmonization obligation that exists only because of the merger and the merger conditions attached to it.
Justice Chaskalson, I share your understanding of the facts, but let me say that the suggestion that there was a breach of the harmonization obligation was not one, there was one raised at one point, but not pursued. So there's no case made in the Commission's suspicion of breach or apparent breach notice of a breach of the harmonization obligation. So with the greatest of respect, that was not the question before the tribunal because it was not raised by the Commission. There was a suggestion of it at an earlier stage. There was a complaint by FAWU, but it's not one that the Commission pursued.
It's two responses to that. The first is, even assuming that that's correct, is it not still a breach of the retrenchment conditions or the retrenchment conditions in that when one looks at these retrenchments, one of the reasons for these retrenchments is that come next year, there is going to be an increased salary bill with because of a harmonization obligation that itself is a product of the merger. So even if you don't see, even if the Commission on the papers weren't to be allowed to allege a breach of the harmonization obligation, don't they come home under a breach of the obligation in relation to retrenchments caused by the merger? Because the harmonization obligation is part of the merger. It's a consequence of the merger. And if the retrenchments are in effect designed to get rid of the prospect of an increased salary bill next year, would that not be essentially a factual reality that there are retrenchments caused in part, at least, by the merger?
With respect, that's not the case that the Commission made in its apparent breach notice. It's the point that it made was that there were duplications foreseen in the bottling plants, as appears from my merger report of 2015, and those duplications have now triggered a merger. So the question whether this was a merger designed to overcome the harmonization obligation of the merger, that was simply not a question before the tribunal at all. And let me also say this, what I understand my client's position to be, and I may be mistaken because I've not focused on this issue because it didn't appear to be the issue before the court. But I understand that obligation to be that we retrenched people and we employed others in their place in a different grade of job, not to avoid harmonization, but to reduce employment costs as a result of the change in economic circumstances. So it was a mechanism employed to reduce employment costs, whatever those costs might have been, and whether they were originally had their origin in the merger or not. And it is therefore not because we were now facing increased employment costs, but because our employment costs were simply no longer affordable, and we employed this mechanism to reduce them.
Well, can I come back then to the structure of the statute and the rule? Because you're saying really that the issues need to be defined by the notice of apparent breach. But if that's so, you can't get a complete get-out-of-jail-free card at the end of this process if what you're saying is that the notice of apparent breach focused on duplication and didn't invite us to canvass issues of harmonization. It will... Two concerns that I have. The first is it must surely, if that is the case, it must surely be open to the Commission at this stage to issue a new notice of apparent breach that looks at the intersection of harmonization and retrenchment and pertinently raises that. That's my first my first proposition that I'd put to you. But the second one, and maybe you can think about both of them when you answer, is that if we're not talking about administrative action and we're really talking about a preliminary inquiry process to decide whether the matter can go forward, even if the issue of harmonization is not pertinently pleaded, so to speak, in the notice of apparent breach, if it's ventilated on the papers, shouldn't that be sufficient to, on the papers before the tribunal, shouldn't that be sufficient for the tribunal to reach a decision that it's not going to give you the ruling that you want, that it's not going to give you the review decision that you want, because this issue has been ventilated on the papers. And on the basis of your client's responses on the papers, they're not necessarily entitled to an absolute protection from further process at this stage.
Well, let me suggest, firstly, on your first question, it is probably open to the Commission to issue another notice. I don't think functus officio kicks in, and precisely because it is merely a suspicion of a breach, and they may say, merely because my yesterday's suspicion has been shown to be unfounded, there is a fresh suspicion for whatever reason. So I accept that there's probably room for a fresh notice. In the hearing, however, the rules of fairness and the rules of audi alteram partem must govern. And if the trigger is a notice issued under 39.1, then fairness requires that that suspicion be addressed under 39.2, and it is appropriate that the firm under suspicion should be entitled to assume that the case made against it is the case raised by the letter. I'm not excluding the possibility that the Commission may designedly change its case before the tribunal. That possibility, I suppose, might be there. But the question before the tribunal, until there is such an avowed change of case, question before the tribunal is the question raised by the notice and not some other suspicion of some other complaint.
Thanks.
Thank you, Chief Justice. Mr. Pengrove, you indicated earlier in a response to my colleague Justice Kippers that even if the breach notice was found to be irrational, that would not serve as a bar to the 39.2 process, and that the obligation on the firm to show substantial compliance would remain. Is that correct? In a sense, it ties up with your criticism both of the tribunal and the appeal judgment that found that fairness, reasonableness was part of the process. Is that a correct understanding?
Indeed.
So arising from that, Mr. Pengrove, if indeed, and you spent some time showing that, attempting to demonstrate that the Commission made factual errors in coming to the conclusion that it did because it really misconceived the information at its disposal at the time of the merger in terms of what category of jobs would be affected and what not. If that is so, then surely on your argument, the consequence of that error can't be fatal, in a sense that once the notice is issued, it brings us within 39.2, if the firm so elects.
Now, I accept entirely that the Commission's error is not decisive of the tribunal outcome. But let me say what I should have added from the beginning, is that the case I advance on that proposition is one that supports the approach and conclusion of the tribunal and with respect, and not the Competition Appeal Court. We submit with respect that the tribunal got it right, but that the Competition Appeal Court did not. And it's attached significance to the Commission's, the basis of the Commission's conclusion.
Okay, good. Given that the matter then was correctly considered on the basis of 39.2, notwithstanding the factual errors, and it does appear that the Competition Appeal Court took into account that particular factual reality that you align yourself with, if one has regard to, I think, to paragraph 75 of its judgment. That being the case, Mr. Pengrove, you make the point that once the appeal court had made a determination that the breach notice was fair and reasonable, that effectively disposed of the matter, And I'm not sure if I understand that argument, because what the appeal court then did is that it traversed the merits, in particular the question of whether the retrenchments were merger specific, and concluded that it was. And in part, it relied on your client's attorney's letter of the 20th of October. And in particular, and you're probably aware of paragraph 8.1.5, where there appears to be some acknowledgement in relating to the retrenchments in question and those at the bottling plant, that they were occasioned by the removal of duplication. So it appears that the appeal court dealt with both the test, which you said got wrong, but ultimately it wouldn't have been of any consequence, but then went on to deal with the merger specific issue and concluded on the facts before it that it was so. What do you say to that?
Justice Colpin, let me say we submit fundamentally that the tribunal got the facts right, and that there was no justification for the appeal court, competition appeal court, to interfere with its finding. The tribunal absolved the applicant, and that would have been the end of the matter had it not been overturned by the competition appeal court. The competition appeal court, however, overturned the tribunal, and we submit with the greatest of respect, incorrectly so. And it made the same mistake as the tribunal had made, and also it attached significance to the attorney's letter, to the Coca-Cola attorney's letter of the 20th of December 2019, the letter to which you referred, and to which our learned friends referred in their heads of argument. I think I counted it 6 times or something. But in fact, the reference to it is unjustified, because it was a letter written in December 2019. In the context of, by the way, the particular paragraph is at page 134 of the papers, in paragraph 8.1.5. And let me just read the whole paragraph for context. And remember, this is in the context of a letter written in defense of my client to the suggestion that the planned mergers are, the planned retrenchments are merger specific. We respectfully submit that it is inappropriate in this instance to draw a correlation between such retrenchments, whether attributable to duplication, staff costs, or otherwise, and reasons attributable to the merger in circumstances where they have been occasioned by factors unrelated to the merger. As dealt with more fully below, CCBSA recognized that certain of the job losses were occasioned by the removal of duplication so as to reduce staff costs and to change the nature of employment within the firm so as to reduce overall costs. So this statement is made in the context of a paragraph that says that retrenchments are not merger specific. And then when it speaks of the removal of duplication, what it later explains is that that is duplication caused precisely by the downturn in the demand for the product of the applicant. It created certain redundancies, whereas previously you might have needed 10 warehouse people. Because of the lower turnover and therefore the lower movement through the warehouse, you now need only 8 warehouse people. So there's an internal duplication caused by the downturn in the economy. It can never be interpreted in the context of this paragraph as suggesting, as referring to a duplication caused by the merger. It's the very context of the statement is a paragraph which says that this is not merger specific, it's due to other causes. So we submit with respect that the Competition Appeal Court got it wrong.
Okay, thank you.
Chief Justice, you're muted.
Sorry, thank you. Thank you, Mr. Tringle.
Yes, thank you. Case from colleagues. We are at 11:45. Oh, no, I think Justice Chaskalson does have a question. Justice Chaskalson?
Thank you, Chief Justice. Mr. Trengo, can I take you to volume 2, page 155, paragraph 24?
Yes, I'm there.
This is your client's supplementary affidavit. Well, let's start to contextualize it. The last sentence of the preceding paragraph. However, it's notable in paragraph 15 on page 382, the Commission recognizes that the harmonization issue would not have been the subject of a complaint at the time, since the obligation to achieve harmonization was only due to be fulfilled in May 2020 after the issue of the Form CC-19 notice. And then your client says, despite that recognition, it appears that the Commission forged ahead with the issuing of the Form CC-19 notice in respect of the harmonization issue. Doesn't that mean that your client was aware that the intersection between harmonization and retrenchment was an issue and needed to be addressed?
Yeah, I simply haven't researched that issue and I can't address you on it now. It was not my impression, but I hadn't taken this sentence into account, and I'll have to consider it and come back to you.
Thank you.
Thank you. I think we'll take the short adjournment. We are at, I think, 14 minutes to 12. So let's come back at 12. The court adjourns.
Court will adjourn until 12. Please note that during the adjournment, you are welcome to switch off your video and mute your microphone, and then rejoin with video and sound when the hearing recommences at 12. Should you exit, you may use the same link to rejoin the hearing.
I hope everybody is back. I think it does look like everybody is back. All my colleagues. Justice Jeffrey, are you there? I don't see her picture. Justice Jeffrey, are you there? She's not there yet. Justice Bantla, are you there?
I'm calling her,
Okay.
yes, I'm calling Justice Chika.
You are calling her. Okay, all right.
Yes. There is no response, Jay. Mr. Naidu, can you please check if she's not in the waiting room?
She is shown as being in the waiting room. Oh, sorry, no, she's shown as a participant.
Okay, I think Mr. Naidu will be checking. Oh, there she is. Justice Chikri, can you hear me? I think you are muted. Justice Chikri, can you hear me? No.
Yes, CJ, I can hear you now.
Oh, okay, all right. I think we are all in now. Thank you very much. Mr. Tengov, I think we had no further questions for you. So I think we'll now allow Mr. Ngwetobi to take the floor. Thank you very much.
I think Justice Matopo might have raised his hand, Chief Justice.
Oh, is that so? Justice Matopo, did you have your hand up? Well,
yeah. I'm not too sure
oh,
whether
did you have your hand up?
Yes, I did, but I reconsidered.
Oh, I'm
but
terribly sorry.
Perhaps now that you have recognized me, I can put the question to Mr. Trengov.
Okay, all right, thank you. I didn't see your hand earlier on.
My fault, CJ. Mr. Trengov, what seems to worry me or concern me is whether we are now called upon, one, to determine whether the correct legal test was applied by the CAC. I've heard your argument. And two, whether in us undertaking that assessment or determination, this is not a fact-laden inquiry. I say this against the backdrop of your initial submissions that the hallmark of your case seems to be that there was a fundamental mistake or a fundamental error on the part of the CAC in formulating the proper approach to the case. And one has to bear in mind the cases, a whole host of cases in this court where it says the misapplication of the legal test does not engage the jurisdiction of this court. Would you then say, because there is an intersection between your labor relations and the competitions, the case is partly factual and partly legal, and it engages our jurisdiction? I just want that clarification.
Yes, indeed, Justice Mtopo, and we would submit in particular the proper interpretation of the rule and the role of the tribunal in considering a review under the rule or matters of constitutional moment, and give rise to fundamental questions before one reaches the factual inquiry.
All right, thanks. Thank you.
Thank you, Mr. Trengov. Oh,
CJ.
I'm sorry, there's another hand. Justice Msandra.
Thank you, CJ. Just one point on the judgment of the CAC. The CAC has criticized the tribunal for not following its own decision, that is BP investment, on the question of the measure specific meaning of measure specific. What is your response to that?
We submit with respect that the BB test may be appropriate in some circumstances, but is not suitable as a general test for causation. Simply to ask whether the incentive of the new controller may be a factor in determining the outcome is, with respect, a test that would sometimes be suitable, but often not. After all, if you take an extreme case, once a merger occurs, then everything the merged company does thereafter is related to the incentives of the controller of the new firm. And to say that all of that is merger specific simply because it's a function of the new owner's incentives is not to say anything about causation at all. So, Justice Msandla, we submit with respect that the BB test is appropriate in some circumstances, not appropriate as a general test, and that the tribunal cannot be faulted for its application of the test that Justice Majid described in this court, which we submit is a sensible test for the causation for a dismissal.
Thank you, Steve.
Thank you. Oh, Justice Chaskason. I think
apologize
after the break, Mr. Trengov, we won't let you go.
Mr. Trengov,
I'm sorry,
it's a question that I was going. Thank you, CJ. Mr. Trengov, it was a question that I was planning to put to Mr. Nkai-Tobi, but it occurs to me that I really need to put it to you first. On your construction of the scheme of the rule, a decision to dismiss a Rule 39(2)(b) application would, in the sort of old language, be a purely interlocutory decision, capable of being, and the issue of substance would be capable of being revisited on the merits in a full hearing before the tribunal at a later stage if it gets there. And no legal consequences flow from the dismissal itself. In those circumstances, how should we approach the question of appealability of dismissals of 39(2)(b) decisions? And although this court doesn't function on the same basis as the SCA does in relation to appealability, we do have to have regard to the interests of justice. So what approach should we take to the appealability of the CAC decision in that context?
Well, we submit with respect that the tribunal acquitted my client, and that acquittal has legal consequences. What the Competition Appeal Court did was to deprive it of that acquittal. So it certainly had serious legal consequences, and for that reason, we submit that it's appealable.
So the CAC decision would be appealable, but if the tribunal had merely refused your application?
Well, if it grants my application, I get a get out of jail free card, so that would has a consequence. If it refused my application, then I would imagine it wouldn't be appealable. It might be reviewable, but I'm not sure that it is appealable, because it is true that it doesn't. No, what it does is to open the door to the Commission for proceedings under the punitive sections. And that is a consequence, whether that door is closed or is open. So we submit with respect that whichever way the tribunal finds, it has that consequence of either giving me a free pass or denying me a free pass to which I might be entitled.
Thank you.
Justice Shashkelson,
Thank you.
I still owe you some better answers to some of your earlier questions, but I'd just like to have a look at the papers and come back to it and reply.
No, I wasn't expecting those answers now. I was only expecting them in reply. Thank you.
Thank you.
But
Thank you, Mr. Chair.
If we're there, sorry, to make the answers. I've lost my references, but the one reference that I did give you, it needs to be viewed with the previous paragraph and the reference to the founding affidavit. I think it's paragraph 48.3. I think it's paragraph 48.3. But if you go to the reference I gave you and you look to the preceding paragraph, you'll see it cross-refers to the founding affidavit. So if you could look at all those three together when you come back to me.
Thank you.
Thank you very much, Mr. Trengov. Mr. Mugaitobi.
Thank you, Chief Justice. I propose to, in the 30 minutes allocated time, I propose to deal with the merits of the case in the sense of the facts of the case and the pleadings, what they reveal. In other words, what was before the tribunal. And also to address why we say that you should not entertain the leave to appeal. You should dismiss the leave to appeal, because the matter does not give rise to a genuine constitutional issue on which a ruling by the Constitutional Court is required, nor does it engage a matter of general public importance on an arguable point of law on which a ruling by the Constitutional Court is required. So on both of those jurisdictional grounds, you should dismiss the application for leave to appeal. Let me start with what the pleadings show. What we know is that there were 4 bottling operations that were acquired by ABI. It was Sapco, it was Coca-Cola Shanduka, sometimes referred to as CCSB, it was Kenas, and it was Waveside, sometimes also referred to as Valpre. And the structure of employment in those is referred to in several parts. In several parts of the record. including in the Commission's report itself, included obviously workers at managerial, administrative, finance, but it also included workers in these three areas where the retrenchments took place, which was in manufacturing, which was in sales, and the last one, in fact, it might be helpful to actually refer the court to the part where this appears in the record. So the court will have regard to, just find that part from the court itself. Yes, it is at page 374, which is volume 4. And that is the best illustration of these divisions. So the third column is Shanduka, is Appletizer, Kenners, Waveside. The retrenchments are in sales, manufacturing, and logistics. And those are where the largest number of employees are. In sales, 1,753. In manufacturing, 2,024. In logistics, 2,950. And that's what gives us the total of 7,549. And the source of that is the major parties themselves. So what we can see there is that in all of these bottlers, there are employees doing the same job, doing the same categories of jobs, manufacturing, logistics, and in sales. Of course, there are also employees in management and administration, and employees in HR, finance, and marketing, also doing the same job or involved in the same job categories, but for the different bottling divisions. Then that's the pre-merger world. You contrast that with the post-merger world, which is in this record that has been helpfully introduced by Coca-Cola as volume 12, particularly at page 1103. What that shows is figure 5, which is the pre-merger world, where there were these exclusive territories rigidly regulated by non-compete clauses. That's figure 5. And there are the different colors from yellow, green, bottle green, and orange, showing that these were different employers with different operations, or different operators with different operations. Figure 6 is a radical revision of that, showing a single employer in one large operation, except for the Western Cape, which remains bottle green. Everything else is then blue, which is one large employer. So that's a radical revision of this. So you're moving from 4 operators to a single operator. But it is also a horizontal measure. It's a measure that is horizontal. It is not a vertical measure where you are taking different operators that are performing different functions. You're taking operators that are doing the same thing. And we see that from that table 22 that Mr. Trengov also relied upon. So that's the structure of this measure. That's what happens in the measure. The Competition Commission then has to ask 2 questions when it assesses the measure under Section 12 capital A of the Competition Act. Question 1 is, would the measure impact on competition? And the question there is, would the measure substantially lessen competition? And if the answer to that is no, it will not substantially lessen competition in a market. It has to ask the second question. What is the impact of the merger likely to be on the public interest? And in this case, the question was, what is the likely impact of the merger on employment? On question 1, the Commission, you will see this at page 281, paragraphs 8 and 9. So 281, paragraphs 8 and 9. Those are the extracts from the Commission's report. 289 at paragraphs, sorry, 281. It's not 289, 281, paragraphs 8 and 9. In both of those, it concluded that the merger is unlikely to have a substantial prevention or lessening of competition. That, of course, is not the full question that has to be answered under Section 12, capital A. It still needs to conduct a public interest analysis. Now, what it did on the public interest analysis, you will find in the same volume 3 at pages 295 to 300. So that's what the Commission did, 295 to 300. Now, when you look at 295 to 300, it's under the heading Effect on Employment. Firstly, it starts by a reproduction of that table to show both managerial and non-managerial employees, because that is what gives us the 7,549 total. And then at paragraph 378, which is at page 297, it's now considering what are we going to do about employment. And what it is answering here, Justices, is the single question. The merger is going to come at a cost. It's going to come at an employment cost. Somebody is going to lose a job because at page 1103, we're moving from 4 operators to 1 operator. So at whose cost will this merger be? That's the question. Who is going to bear the burden of the merger? The merging parties say to the Commission, the burden of the merger will be borne by managers and executives. And that is what is at page 3, paragraph 375. That is where they say the merging parties have indicated that the implementation of the proposed transaction will result in the duplication of 387 positions, non-bargaining unit employees, at executive, managerial, administrative, and technical level. And the parties have, however, reduced the number of job losses from 387 to 250. So it's the merging parties who say the cost of this merger will be borne by executives. It will not be borne by bargaining unit employees. FAO, however, at page 297, paragraph 378, has a different perspective of this. It says, well, it's not accurate that the cost of this merger will be borne by executives. It says to the Commission, FAO informed the Commission, you see this at paragraph 378, FAO informed the Commission that unskilled employees tend to be affected at a later stage, i.e., after 2 years after the parties have merged. And parties always claim that such retrenchments are not as a result of the merger. In light of the above, FAO has informed the Commission that it must place a moratorium on retrenchments and strictly scrutinize retrenchments that may be expressed as non-related to the proposed transaction. Both of those are then accepted by the Commission. One is the expression by the merging parties that the cost of the merger will be borne by executives. But FAO's concern that the cost of this merger will also be borne by bargaining unit employees is accepted. This is what gives rise to these conditions. And we know this for a fact because when we look at how these conditions began, they began on the 5th of May, 2016, and you'll see this at page 43. Now, at page 43 is a memorandum of agreement between FAO and SAB Miller, which is these parties that were acquiring these bottlers, and Coca family and the Coca-Cola. So the merging parties want to get this merger past the tribunal. They want this merger not to be opposed. And that is happening on the 5th of May, 2016. what they then do is, under item 2, is they then strike an agreement with FAO. FAO agrees not to oppose the Competition Tribunal proceedings in respect of the proposed transactions if the following paragraphs are included as conditions of the merger. There are 3 of those conditions. One is harmonization. Second is Black economic empowerment. And the third, which is at page 44, item 5, is retrenchments of bargaining unit employees. So harmonization, BEE, and bargaining unit employees are then taken from the agreement and then included in the conditions in order to incentivize FAO to drop its opposition. And that's how the agreement then arises. Now, interestingly, the framing of the non-retrenchment of bargaining unit employees at paragraph 5.1 in the last sentence of paragraph 5.1 says, for the avoidance of doubt, there will be no measure-related involuntary retrenchments within the bargaining units. So the agreement between FAO and the merging parties is anything that's measure-related. And I know in this appeal there has been a lot of focus on the words "as a result of," when in fact the origin of the agreement was anything that's related to the merger. Now, those are then taken into the conditions as they are. We have a harmonization condition, we have an employment condition, we have a BEE condition. The BEE condition, we can drop it for current purposes. Harmonization and the employment conditions remain. And that is what we find 5 days later on the 10th of May, which is the conditions imposed by the tribunal at page 27. The language changes at clause 9.1. It's no longer merger related. It's retrenchments as a result of the merger. But what they are trying to do is to give effect to the agreement that was concluded between the unions and the merging parties, that anything merger related in the bargaining unit will not be affected by retrenchment. So that's how this deal comes into being. And those wordings are crucial. That was the bargain that was arrived at. What do we know after the merger then? What has happened since the merger? What we know since the merger, firstly, in relation to executives, remember that on the executives, although the merging parties contemplated 387 to lose their jobs, they were allowed to retrench 250. They gave their first compliance report, as my junior called it, non-compliance report. In June 2018, the employer gave its first compliance report with these conditions. And that you will find at page 449, which is volume 5. And they tell us a story of what happened to the management employees, and particularly at 450 between line 20 and line 30. And I don't want to read that. In essence, what they say, although we are allowed at executive level to retrench 250, we will be retrenching less than 100. So the executives who were meant to bear the cost of the retrenchment, 150 of them are saved from the cost of from the cost of the merger. In the 2019 report, and the relevant part is at page 472, they then speak about retrenchments at bargaining unit level. So in other words, although there was an express undertaking that there would be no retrenchments at bargaining unit level, there were in fact retrenchments at bargaining unit level. We see that at page 452. So then the names of the people that have lost their jobs, we also know them. And those we will find at volume 2, pages 101 to 106. There are just 2 points I want to make about this. This is a list as Annexure B. What we know about this list is that these are the lowest category of employees, there are only probably 2 that have matric qualifications. Everybody else has no record of any qualification. That's number one. The second one is looking at the nature of the employment that they perform. These are typical blue-collar workers. So they are the ones who have now borne the brunt of this retrenchment. And it's in that context then that we have to examine the issue about the relationship between these retrenchments and the merger. Now, what do we know on the pleaded case, which was before the tribunal? What was pleaded as the rationale, let's call it like that, rationale of the retrenchments? The first thing we know is the letter of the 20th of December 2019 from Bowman's. And that letter is quoted in the judgment of the High Court, and it was referred to by Mr. Trengov. That letter says, Coca-Cola recognizes that certain of the job losses were occasioned by the removal of duplication. So that's one. So we know the retrenchments are occasioned by the removal of duplications. And then even in the heads of argument here in the Constitutional Court at paragraph 63, Coca-Cola accepts that these retrenchments were inter alia directed at the removal of duplications, although there is persistence that the duplications have not been caused by the merger. But what do the pleadings tell us about the cause of the duplications? What we know from the Competition Commission in relation to its own answering affidavit is that it expressly says that these duplications have their source in the merger, and these are not duplications at managerial level. These are duplications at bargaining unit level. FAO says 229 of our employees have been retrenched, and the employer accepts its common cause in the replying affidavit that the retrenchments took place in the bargaining unit. So then we go to, well, what was the cause of these duplications? We also see that from the pleadings. If we start with the replying affidavit, to remember that the replying affidavit is responding to paragraph 30.2 and paragraph 30.22 of the answering affidavit of the Commission, where the Commission expressly, and those paragraphs you will find at page 227, 228, and 229. And paragraph 30.22 says the retrenchments of those employees were from the bottling operations of the merged entity where the duplications occurred as a result of the merger. So it's expressly pleaded as such. What does Coca-Cola say in the reply to answer that? We see their response at page 265. It's very important to actually go to that page 265, which is in volume 3. And at paragraph 22. So they have to answer the question. It's common cause that the retrenchments have occurred in bottling. It is common cause that the retrenchments have occurred within the bargaining units. It is common cause that the retrenchments have been aimed at removing duplications. What they then have to answer is the point made squarely by the Commission that these duplications are related to the merger. And the Commission puts that case squarely to them. They say in paragraph 22 of the replying affidavit at page 265, in addition, the fact that Coca-Cola hired 1067 employees in or about May 2019 into the same or similar roles as those explained above, albeit at a lower wage level, stands as clear evidence against any alleged attempt to remove duplications in such roles. Clearly, Coca-Cola's motive was not to reduce the duplication of roles caused by the merger. So they were not aiming to reduce the duplication of roles caused by the merger, but rather to reduce its total employment costs for operational reasons, which were caused by the factors explained in the founding affidavit, including the sugar tax. Now, what they cannot get away from is the relationship between the duplications and the reduction of the duplications, which they have admitted twice. In addition to this, at paragraph 45.12, which you will find, 45.12, which you will find at page 271 of the replying affidavit, which is answering paragraph 31. And by the way, the answer to paragraph 30.2 is at the same page, paragraph 44. So what they say here is this. At paragraph 45.12, they say it is incorrect to reason that simply because some of the retrenchments were in respect of functions that had been identified in the report in the merger to be duplicated means that the retrenchments in question are merger specific. Why? Operational reasons accounted for the need to retrench. But this is the second time where Coca-Cola, in its own replying affidavit, not only does not deny, but admits the duplication of roles caused by the merger and retrenchments in respect of the functions that had been identified in the merger to be duplicated. And where was this identification? The Commission says, this is what they are responding to. The Commission says the identification is table 22. And table 22 is the table that shows you the largest number of employees in sales, in manufacturing, and in logistics, which the Commission says you gave this to us in order to show duplications below managerial level. And these are the two answers that they have given. So no, this is not a criticism against Mr. Lotter, who is the attorney, for writing the letter of the 19th of December. It is his client that made the concessions on the papers. So what are we looking for? We are looking for the relationship between the retrenchments and the merger. What do we know? We know that some of these retrenchments were aimed at reducing the duplication. We know that the duplications in part were caused by the merger. Therefore, do we have a merger relationship to the retrenchments? The answer is, it is manifestly obvious. And that's the pleaded case that was before the tribunal. Now, the problem was that the tribunal misdirected itself in asking an irrelevant question about what the principal reason for the merger was, instead of asking a much lower level question, which is there a relationship? In other words, are these retrenchments related to the merger? Is there a relationship? Not the sole relationship, not the most dominant relationship, but is there a relationship? Now, that question, is there a relationship, is what the parties themselves who agreed on the 5th of May 2016, they said anything that is related to the merger. That is what the parties had agreed upon. And that is why actually on the facts that were before the tribunal, this case was straightforward. The facts were clear that there is a relationship between the merger and the dismissals. Now, that takes me then to what to do about the second relevant fact here. So the first one is relationship between merger and the dismissal. Second relevant factor is the harmonization obligation. How was that dealt with in the pleadings? What we know about the harmonization condition is that it's actually pleaded, and you'll see this at page 234. It's pleaded by the Commission. 234 at paragraph 42 as an explanation of the decision that they made. What they say is that, look, we hear this point about the impact of the sugar tax, but this is the point we are making. They say regarding harmonization, the team, that's the Commission's team, correctly noted that it was not able to assess whether a breach of the condition has transpired. Why? The issue of harmonization merely shed light more light on the underlying motives behind the retrenchments, which were couched as operational in nature. In other words, what they're saying here is simple. You have to put everyone on ABI level by June of 2020. What you do, you retrench and hire at the same time. What are you doing? You are retrenching the lowest skilled, lowest qualified, and replacing them with better qualified at lower pays. So that when the harmonization obligation kicks in, you are harmonizing at lower pay, not harmonizing at the ABI higher pay. It's the Commission saying that. It is supported fully by FAO, and you will see FAO's answering affidavit at volume 2 makes the point even stronger than the Commission made. You will see that from page 171 and paragraphs 8.4, where FAO says this is evidence. That's why FAO is explaining why the sugar tax is a cover-up. They say this is evidenced by the fact that in the same month that retrenchments were effected, Coca-Cola employed new employees in the same or similar position as the retrenched employees, which Coca-Cola alleged to have become redundant, but negotiated lower wages. It might be so that the Commission is not empowered to investigate Coca-Cola's employment conditions, which includes wages, but in this case, that fact is relevant evidence. The conditions required Coca-Cola to embark on a harmonization process within 4 years from the date of the approval of the merger. This process required Coca-Cola to harmonize the wages, conditions, and benefits of employees across the different entities forming part of Coca-Cola. The harmonization process would have resulted in the increase of Coca-Cola's labor costs. Coca-Cola embarked on a retrenchment process to reduce its labor cost. Paragraph 8.7, in addition, the merger resulted in the duplication of positions within the merging parties. The retrenchment process was also embarked to remove these duplications. So that is how harmonization is dealt with. Now, why is this relevant that I have to take the court through the...
I'm sorry, Mr. Ngoitobi. You have exhausted your time, but I'll give you 5 minutes more because I gave Mr. Chengo 5 minutes more as well.
Thank you, Chief Justice. I'm about to conclude on this point. Why is this relevant, the debate on harmonization? It is relevant because on Coca-Cola's construct of the case, what they say is, and we see this at volume 1, on their own construct of the case, what they want, which in their notice of motion, is a declaration of substantial compliance. At volume 1, page 2, paragraph 2, is a declaration of substantial compliance. Now, can they get a declaration of substantial compliance with the two conditions that remain relevant? In circumstances where the Commission says the retrenchments are motivated by the desire to circumvent the harmonization obligation, can they get a substantial compliance declaration in circumstances where the Commission says on credible evidence, which in parts appears to be admitted, that the retrenchments bear a relationship? Doesn't have to be an exact relationship, but they bear a relationship with the merger because they are intended to remove duplications. And there is at least some evidence that the duplications themselves occurred as a result of the merger. And I heard Mr. Trengov saying that the duplications occurred as a result of changing economic conditions. I have asked my junior to look at the record. I don't recall Coca-Cola making that point at all on the pleadings, explaining the cause of the duplications. The only two parts we could find are where they say that the fact that the duplications are caused by the merger doesn't mean that the retrenchments are merger specific. So to conclude on this point, they cannot get a declaration of substantial compliance in circumstances where there is a problem of harmonization and in circumstances where there is a problem of merger specificity. Yes, and in fact, there was a third requirement, which is the head count, that the head count also had to be kept at a certain level. Now, I accept that head count did not feature to the same level as the harmonization and the measure specificity of the retrenchments as featured in this case. So that is what the record illustrates, and that was the evidence that was before the tribunal. And this is why we say the tribunal misdirected itself by asking a principal reason question instead of asking a relationship question, which is what it was required by the FAO agreement. And that FAO agreement had been transposed into the terms of the settlement. Then I should explain why we say, despite everything I have said to try and illustrate that the case of the commission, in fact, was always strong on the merits, you should nevertheless refuse the entire application. I'll do this in 2 minutes, Chief Justice. Firstly, we say the question about measure specificity, measure relationship, or measure causation is a question of fact. That's not a question of law. Mr. Trengov says there is a prior question. In other words, what is the right question to ask? But you still have to ask, is it in the interest of justice to ask that prior question in a case like this? Now, here, it was always accepted by everybody, from the tribunal to the Competition Appeal Court, that the test that must be applied is from BB Investments. We debated as to which side of BB Investments we fall, but nobody ever questioned the applicability of the BB Investments test. No one. It is questioned for the first time at the Constitutional Court. It cannot be in the interest of justice, no matter how interesting that legal debate is. It's not in the interest of justice to debate it for the first time here. If BB Investments was wrongly decided, as you are now urged to find, that is a debate that must take place at the tribunal. The tribunal must be invited to reconsider, and it's a debate that must take place at the Competition Appeal Court. And here it did not take place precisely because Coca-Cola and us accepted that BB Investments was the correct law, and the debate was which side of BB Investments we fall. So there is no interest of justice that impels the conclusion on that issue in this case, bearing in mind that it was expressly considered. Then there is the issue about the meaning of clause 9.2 of the conditions. That clause is not a regulation, it is not a statute, it is an agreement between the parties. It's giving effect to an underlying agreement between FAO and ABR. There is no basis why an agreement between the parties intended to pass through a measure worded in its particular fashion should be decided by the Constitutional Court at all. So this was a deal to pass through this measure. We don't know future deals, what they will look like. They might contain different wording, but there is no precedential value of this particular case to future cases. That then leaves the question of Rule 39(2)(a) as to whether there is a basis for the court to exercise.
Your time is up.
Thank you, Chief Justice.
Your time is up. Thank you.
Yes, I will wait.
You stand by your written submissions on whatever you haven't touched.
Yes, my written submissions speak for themselves, but at this point, I have no further right to speak.
Yes. Thank you. Justice Chitri has got a question for you.
Thank you, Chief Justice. Mr. Ngugaitobi, let's probably start where you were going. Rule 39(2)(b). It worries me because you and Mr. Trengove are not at idem as to the standard of review. And it worries me as well because I look at the text of Rule 39(2)(b) and I battle to find how we can then read this to also refer to a review in terms of a legality review or a PAJA review. Let me stop there for now.
But Justice Chipu, let me make my first, and then I'll answer your question. The question for the Constitutional Court is, should it reach a decision on Rule 39(2) A or B? In circumstances where it was always common cause between the parties that what was happening here was a review. And there was a debate about the standard of that review. But it was never an issue that what was going on was a review of the decision by the Commission to issue a non-compliance notice or an apparent breach notice. Now, for the first time on appeal, there is an issue about whether or not Rule 39 means that there is no decision by the Commission that is capable of being reviewed and set aside, or whether it means that the issue takes place for the first time at the Competition Tribunal. Question for the Constitutional Court is, why should the Constitutional Court adjudicate that dispute for the first time here? Why should that dispute not be adjudicated by the tribunal or adjudicated by the CAC? So in the first instance, we say it's not in the interest of justice to resolve that issue. Now, if you were to entertain it, we would still ask the question, for what purpose? Because the factual issue is outside of scope. The issue as to the causation versus linkages to the dismissals is also out of scope. And so you cannot decide Rule 39(2) in abstract. And on its own, it doesn't give you jurisdiction. Now, what do we say it means? We say that what that rule contemplates as a whole, one is the Commission must first make a determination as to whether or not there has been a breach or compliance with a major condition. Once it has made that determination, it must, in fact, under an obligation, it must issue a notice of apparent breach. It's clear there that the Commission then takes into account a number of factual circumstances, including representations from the defendant, from the merging party. And then it comes to a determination. And that's a decision. It may be that it is not a decision under PAJA, but it is a decision nevertheless. Thereafter, the merging party has the option of complying, alternatively of challenging. When it challenges by way of a review. Now, we say the choice of the word review has consequences, particularly because elsewhere in the same body of rules, the word reconsideration is used and the word appeal is used, which means that the minister intentionally deployed the phrase of review to distinguish it from reconsideration and to distinguish it from appeal. But what is this review then in substance? It surely must include a review of whether or not the Commission was justified in coming to the conclusion that there had been no compliance, which would justify the issuance of a notice of breach. What the power of the tribunal is very simple. The tribunal has a ground of review in the same way as you have under Section 145 of the Labor Relations Act, simply grounds of review. But it's still a review. You're still reviewing the exercise of prior power, but you're doing it on the ground of substantial compliance, and you're doing it on the evidence that is before you. You don't ignore the Commission's decision and act as if it does not exist.
Thank you. You were obviously listening to the debate between Justice Mhlandla and Mr. Trengrove about whether we can then say that there is a decision at all at this stage. I'm not going to take you back there. My other concern, well, let me just say to you that I share, that sentiment, that it doesn't seem that at this stage, when the Commission issues a notice of apparent breach, it is a decision that is reviewable. Let me just put that so that you are aware. You can deal with it if you like. But I'm also concerned about the relationship issue that you've traversed. the relationship between the merger and the retrenchments. Am I correct in saying that the merger conditions, they anticipated that there could be retrenchments, but only based on operational retrenchments, not merger specifics? Am I correct in my understanding of that?
Yes, no, there is a specific clause. That's what I'm looking for at the moment. It's a later.
I thought it was clause 9.4, but when I looked at it when you were making submissions, I couldn't find it in clause 9.4.
Yes, no, it is 9.45 at page 39. So
Yes.
It says 9.45, necessary steps taken by the merging parties in terms of section 189 of the LRA should operational requirements in the ordinary course of business that are not merger specific necessitate that such steps be taken.
Yes, okay. Now, what I'm wondering about is whether you do dispute that Coca-Cola had to pay a sugar tax of around 2.1 billion, whether you do dispute that its profit had decreased, and whether you do dispute whether the price of sugar and other raw materials increased post the measure.
Yes, what the commission said on that point. In fact, I must find so what the commission said, if you go to the answering affidavit of the commission, you'll find this at volume 2. Yes. So it starts at 183 and 184. And then it goes on. There's a specific passage that I'm looking at. But I can give you a summary of what it said. What it said was this. You claim that there is a sugar tax that has been imposed from, I think, 2017. But as far as we are concerned as the commission, the causa of the retrenchments at bargaining unit is duplication. In other words, it's the same employees doing the same jobs. Duplication. In other words, it's not let's close down a unit because of high cost of labor, but it is let us eliminate duplications. That's number one. Number two, you are hiring at the same time as retrenching. And when you are hiring at a low wage, not at ABI level, at low wage. And then they said for those two critical reasons, which is a retrenchment intended to remove duplications and duplications that have occurred as a result of the merger, there is a relationship. Number two, when you are retrenching at lower level, and you know that in a year from now, you have a harmonization obligation, we will regard that as a circumvention of the harmonization obligation. And on those basis, and that is what is pleaded in the answering affidavit, and you will find this in the memorandum of the 30th of August 2019, which was the basis on which the commission took this. And we will regard this as related to the merger.
So basically, the commission disputed that the reasons advanced by Coca-Cola were the reasons for the retrenchments. Yes. Are you saying that?
No, I think the point to be made here is twofold. One is the true question the commission had to ask itself was whether there is a merger relationship. And in answering that question, it took into account two facts that seem to be common cause on my analysis earlier. Fact one, The retrenchments are aimed at removing duplications. Fact 2, those duplications have arisen, at least in part, as a result of the merger. Now, insofar as these are the reasons that have been given, those will be reasons that will be adjudicated by the Labour Court in due course. They are not reasons that fall within the jurisdiction of the Competition Commission. The Competition Commission is only responsible to assess if there is a link between the dismissal and the merger. And it has found that link in duplications, 2, in harmonization.
No, I hear you, but the commission did not dispute that the price of raw material and sugar had gone up. And when it compared the income statements for the 2017 and 2018 financial years, it saw that there was a decline in revenue. And it also did not dispute that there was a bill of around 2.1 billion that was paid.
Yes, Justice Shiko, let me come back to this point. That was an irrelevant consideration for the commission, because the commission's jurisdiction was always limited to the merger conditions. There was no merger condition relating to the sugar tax. There was no major conditions relating to the profitability of the business. The only major condition was related to duplications and the keeping of a particular level of employees, as well as harmonization. Once the commission satisfied itself of the link of the relationship, it was entitled to exercise its powers in law. The fact that in the Labour Court in due course, there will be a debate about the justification of these other considerations is irrelevant to the commission. If the commission had now gone to examine the rationale given by Coca-Cola, I mean, even Mr. Trengov in his submission, it would have been found to be acting outside of scope. Its only question was, can I draw a link between these retrenchments and the merger? And it found that link in duplications, and it found it in the attempt at circumventing harmonization. That was enough for the commission. It didn't have to do anything else.
Thank you, Chief Justice. Thank you, Mr. Ngubaitu.
Thank you. Justice Rogers.
Yes, I'd just like to get a bit of clarity, and perhaps I don't understand the facts as fully as counsel will, but it does go to the facts. I understand the evidence to be that of the 368 or so bargaining unit employees who were retrenched, only 21% of them came from ABI. There was a large percentage from, I forget which of the OSABCO, or 69% and 10% Shanduka. In the context of the harmonization obligation, the people who earned better than the ABI minimum levels weren't allowed to be reduced. Their right stood. But people who were at less than the ABI minimum levels had to be brought up to the ABI level by a certain date. Is that correct?
Yes, that's correct, Justice Rogers.
So it seems to me that retrenchments that were causally connected to the harmonization obligation, in the sense of having an eye on what the company would have to do by May 2020 in terms of the harmonization obligation, could only conceptually be relevant to retrenchments within ABI. Because if we take SABCO, for example, which is where 69% of the employees, retrenched employees came from, if new people were employed at lower levels than had previously been the case, they would still have to be brought up to the SABCO level by May 2020. So am I right that the only way in which a company trying to reduce the impact of the harmonization obligation could achieve that through retrenchments would be by lowering the minimum rate at the SABCO level?
Yes, well, I mean, yes, I suppose you could, yes. I mean, how would you achieve it? You see, so you would have to first, because what had happened here, let me just answer that question first. I'll come back to the question, Justice Rogers. What had happened here on the facts is that all of the employees on the common cause facts, in May 2019, when they were retrenched, they were then offered re-employment on lower rates. They rejected it. And then they stayed dismissed. And then that was 368, and then they employed another 243, which left around 170 still dismissed. So around 243 were then brought back. But it seems that bringing back was then across. See, it was then across these divisions that they then were brought back on lower terms. So one way of achieving it could be we must first introduce new terms, and those new terms would include high skills, lower wages. And we must retrench them. Yes.
No, I think I interrupted you. Carry on.
Yes. Retrench the existing ones and then offer them, because that May 2019 offer makes no sense otherwise. The offer to everyone.
Yes, but at whatever terms they were re-employed, the harmonization obligation would still require them to be brought up to the SAPCO minimum level by a certain date that lay in the future at the time of the retrenchments. So the only way you could, as it were, minimize, as the company, the employer, minimize the impact of the harmonization obligation was to lower the level of the minimum wages within SAPCO by the time you had to comply with that obligation.
Yes, I would accept that. So I think I thought we were asking the May 2019 question.
No. And it then seems to me to follow that any retrenchments, that the 79% retrenchments that occurred in the, let us call it the former divisions outside of, apart
outside
from
of ABI.
Outside of ABI, could not have been intended to minimize the impact of the harmonization obligation, because come what may, by the time that obligation stood to be fulfilled, if they were below the minimum ABI level, they would have to be brought up to that level.
Yes, I can't argue against that proposition. The only point I can make on that is simply that what you have to then consider on harmonization is whether there is a relationship, partial or full. And if the answer to that question is yes, can you issue then a notice of substantial compliance?
If one then says, well, the 79%, I don't say you've quite conceded this, but if you assume that the 79% retrenchments couldn't have been related to minimizing the impact of the harmonization obligation, then one has to say, well, what did cause it? And what one is then left with is the company's version about the economic circumstances and the sugar price and the sugar tax. All of these were requiring it to reduce wages. If we were to find that that must have been the reason for the 79%, doesn't it cast a long shadow over the 21% from ABI? Because the question would then arise, why would anybody find that the reason for retrenching 21% from ABI was any different to the 79% from the other companies?
Justice Rogers, there's still a problem that they can't answer, which is the retrenchments motivated by the need to remove duplications, and the duplications having occurred in the bottling divisions.
Yes, that was going to be my third and last question or topic. Just remind me, as I understand it, although these bottling companies came under new ownership, they continue to exist as companies, but now under a single controller? Or
yes, it's sorry. It's unclear whether they would continue to exist as different companies or as different operations within the same controller. Because what we know, I mean, it's actually what we know is that after these dismissals, so if you go to 450, in that compliance report, so that's the part I didn't read in my main address. So at line 20 to 30, what seems to have happened is that although there was a contemplation at the beginning, in other words, when the merger was considered, there was a contemplation of who they thought would be retrenched because of the changes at head office level. There was still the problem that below head office, you still have these people doing the same jobs. And that's the import of table 22, still doing the same jobs. Now, what then happens after the merger has been approved? What we get here is they say, however, given the duplication of roles that we have discovered since the merger, so since the merger, they discovered duplication of roles. And then, of course, this is purporting to address reduction of management positions. And then later on, you're trying to understand, well, what do they say about the bargaining unit? You get that at 452. And again at 452 in the third paragraph, where they're talking about optimization, say, this optimization has been brought about by a myriad of factors, chiefly that some of the business units are still not profitable 2 years after the merger. And we ended up, and this is the point I was trying to make, we ended up with duplicated processes and positions among the highest earners in the company. So what seems to have happened is that although in the merger report, and the portions Mr. Trengov was reading are not the findings of the commission, they were submissions by the merging parties. So they submitted that our own contemplation is that there will be duplications at head office level, and that will result in the retrenchment of 387 employees. But even that idea seems that they discovered new duplications post the merger. And these are not only duplication of employees, duplication processes and positions among the highest earners. This then explains why it's been difficult in the pleadings to distance themselves from duplications as a causa.
I think I might have got you off on a tangent, which I hadn't intended. Let me for the moment assume that the effect of the merger was that the four companies that previously existed, their operations now simply became divisions owned by one company.
Yes.
I think that would be the most favorable basis from your perspective to ask what I'm going to ask you, to answer what I'm going to ask. My understanding is that because of the historic exclusivity that the four bottlers previously had, it was there wasn't overlap between the operations, and from a practical point of view, those four bottling operations were going to continue. And my understanding, it may be wrong, is that when Coca-Cola talks about duplications, it's not talking about duplications across more than one region. It's talking about duplications within any one region. So if we take typical job descriptions of the persons that were affected, like a battery bay attendant, there was if you had one battery bay, or say you have 3 battery bay attendants in one region and 3 battery bay attendants in another region, you couldn't have one battery bay attendant now doing the work of 2 regions. The idea might be that you only need 2, not 3 battery bay attendants in that region, just for example. So what I wanted to know was, is there any evidence that the elimination of positions or the rehiring that occurred ever had an inter as opposed intra-region effect? Was it ever more than cutting down positions within any one of the 4 previous regions? Because if it was only cutting down, if they looked at each region and said, how many bodybuilders, I assume those are people that build vehicles, semi-skilled artisans, transport assistants, how many does Gauteng need? How many does Port Elizabeth or the Eastern Cape need? It wasn't looking across regions, or do you say there is evidence that these retrenchments and rehirings eliminated duplications which somehow straddled regions in a way which didn't exist previously? It couldn't have existed previously because they operated exclusively within their own regions.
Yes, but Justice Rogers, I would say the answer ultimately, even on both of those postulations. So case one is this an internal reorganization? Case
internal
two is
from the perspective of any one region. Yes.
Yes. Is it an internal reorganization? Case two, is it an inter-regional reorganization?
Cross-border.
Sorry, Justice Rogers has now disappeared from my screen. Oh yes, okay,
Well,
I can see you. Sorry. Yes. No, sorry, I can see it. But on either of those outcomes, that does not take them away from merger relationship, because if you're looking at the BB investments test, the BB investment test focuses on the incentives of the new controller. So what you have here, you have a horizontal merger, 4 into 1. So 4 operators into 1 operator. An operator in Boksburg may decide that I need 12 forklift drivers. And then operator in Germiston may decide I also need 12. But a single operator might decide that actually instead of having 12, I should have 4 in each of the regions. So even on the intra-regional reductions, it still does not take away on the BB investments these likely incentives of the new operator, because the game after the merger is optimization of efficiencies.
But it does it does mean that one's justification for finding that there is a merger relationship is substantially different. If in the sense of the head office and admin workers, the idea there was there had previously been 6 head offices, and the new controller had in mind to reduce that to 1 with up to 250 or whatever it was retrenchments. That was a very direct merger relationship, a rationalization that is able to be brought about by the merger. But if, in regard to the bargaining unit people, there were 4 units and the trimming all occurred separately within each unit, you don't have that same obvious connection. If you say, well, it's still the new controller who decides that he can do with fewer bodybuilders or battery operators in any one region, you're coming to what Mr. Trengove says is an unacceptably wide concept of merger relationship, because in that sense, every business decision that is taken after the merger is taken by the new controller. The new controller may think he can operate more efficiently, and in any one region he can do with 11 people in a particular job rather than 15. But surely the mere fact that the decision is taken by the new controller can't be the answer, isn't it? The new controller has taken this decision in the light of macroeconomic circumstances, increases in the sugar price and the sugar tax. If those are the reasons that has caused the new controller to cut down numbers intra-regionally, then can it still be said that that's a merger relationship?
Yes, but if the new controller tells you that I want to eliminate duplications, then it seems very difficult to then take that new controller and say, well, I am retrenching because I'm trying to remove duplications. And the debate we were having earlier was, are these duplications being removed internally or are they being removed also externally? And the point I make is that the incentives of the new controller do not change. But there is a factual answer to that actually the facts are not as clear-cut, because this distinction, because this entire debate takes place on the assumption that there is a distinction that can be credibly drawn between head office and, let's call, the operators. But if you actually look at the structure, which is at page 295, and maybe we should go there, and that's the table that everyone has been dealing with. If you look at the actual structure, there are in fact no such clear-cut distinctions, because let's take HR, and all of them actually, there's 7 categories. Whatever HR, what you have there is precisely the same. So there are people in HR at CCSB, Appetizer Kenner's website. The same with finance, the same with marketing. Let's exclude sales, manufacturing, and logistics because that's where the retrenchments took place. Or the same with management. So on the facts, actually, it's not clear that management sits in one particular area. It seems that they are all spread across. That's one thing. The second thing, what we get from this is that
sorry, if I could
management
just,
is also,
but you yourself emphasize that the people that are affected within the bargaining unit are the blue collar workers.
yes,
I think you drew our attention to only 2 of them having a matric qualification.
yes,
So these are unlikely to be persons who could perform a single function across more than one region.
yes, no, all I'm saying is that
whereas an HR person can do HR potentially for the whole country.
well, yes, that is true, but I'm simply saying that even within this bargaining unit employees, sales, manufacturing, and logistics, even within there will be a number of people that are performing management and admin jobs. That's the only point I was making. And that's why I'm saying the distinction is not as clear-cut, because when you look at the actual numbers that we were dealing with, we are dealing with management spread across and management not separated from the operations of the entity. And so that's why the justification that says management must be looked at differently from bargaining unit employees is not, in fact, entirely supported by the evidence. And so let's come back then to the principal question, a removal of duplications within manufacturing. What do we know about whether or not entire entire regions were closed down and then new regions were reopened? Well, there is no clear-cut evidence on that. I mean, the best we have is page 101 up to 106, which is the actual names of those employees. We have them separated there by region in terms of the area. So you have the entire coastal commercial with 81 people gone, and the entire coastal logistics with 14 people gone, and the entire Gauteng commercial with 11 people gone. And then when you look at inland, you have all of that 51 gone, inland logistics, all of that 38 gone. And then North commercial, all of that 81 gone, North logistics, all of that 109 gone. So we also have an inter-regional description of these losses. And these are big numbers. If you just one more point, Justice Rogers, I apologize. If you compare those to sales, logistics, and marketing, these are big numbers that are, in fact, geographic in 81 people from one geographic area gone, as opposed to 2 people from this geography, 2 people from that geography. What you have is 51 from one geographic area gone. Then you can then draw your own inference about whether that amounts to a closure of a geographic region or not.
Thank you. I'm finished.
Excuse me, Mr. Chair. We've lost Justice Chikri. She's disconnected. Zunaid, will you please check?
Okay.
I think I'm back. I'm back.
Okay. Thank you.
Okay, thank you.
Thank you very much. I don't see any further indications from colleagues. Mr. Ngwachobi, thank you very much.
No, I see Justice Dodson has got his hand up. I'm sorry, Chief Justice, to usurp your function, but
well, it looks like counsel are able to see what I can't see. Justice Dodson, is your hand up? Justice Johnson, is your hand up? I can't see.
You are muted.
I've unmuted myself, Chief Justice. Apologies.
Yes.
Oh, okay. Thank you. Was your hand up?
My hand was up, Chief Justice, yes.
Oh, thank you. Go ahead.
Thank you. And I'm indebted to you, Mr. Mukaitobi, for noticing. Mr. Mukaitobi, I want to chat to you about the BB judgment, and you'll need to just give me a moment to get it onto my iPad. You'll just bear with me for a moment. The question I want to put to you is this. The Competition Appeal Court in this case, at paragraph 82 of its judgment, referred specifically to paragraph 56 of BB Investments. And paragraph 56 is that paragraph that reads, it means conceptually an outcome that can be shown as a matter of probability to have some nexus associated with the incentives of the new controller. Isn't the problem with the court having done that you can't really read 56 of BB in isolation, because there's really a discussion that starts at 55, in fact. What does merger specific mean? But it continues. It goes through 57, 58, I think all the way through to paragraph 67. And the first proposition I want to put to you is that isn't that the proper way to get an understanding of what BB Investments meant, is to look at all of those paragraphs as a whole and discern from those what the court was trying to say about the causation issue?
No, I accept that. I think you've got to read the judgment as a whole, but whether or not that is a flaw in the CAC approach is unclear, because paragraph 56 seems to be sort of self-contained. It means conceptually an outcome that can be shown as a matter of probability to have some nexus associated with the incentives of the new controller. So it seems fair as a court of appeal to extract that and to apply it as your sort of guide to interpretation of measure specificity.
My difficulty, though, is I think if you look at the paragraphs together, you come back to what seems to me to be a more conventional, if I can call it that, conception of causation. And in particular, if you look at paragraph 66 of BB, it says, in competition analysis and mergers, we typically compare the pre-merger counterfactual with that of the post-merger scenario. Such an approach seems equally sound in evaluating the public interest, provided any inferences sought to be drawn are arrived at carefully. Now, isn't what the court is there saying essentially the same thing as the but-for test, where they say, look at the counterfactual? What they mean is, look at the pre-merger situation, think the merger away, and ask yourself what would have happened.
Yes, I think the qualification, though, with the but-for test is that the focus is on the incentives of the new controller. So in other words, what would so firstly, in paragraph 56, an outcome that can be shown as a matter of probability to have some nexus. So that's also crucial, because it's not a direct nexus, but it's some nexus, which is a much lower threshold than the but-for test, associated with the incentives, and that incentives is very helpful. Now, why is that so? Is because it's trying to impose an objective standard. It's not trying to be straitjacketed by the idiosyncrasies of a specific controller, but it is trying to set an objective standard, which is for the judge to ask themselves the question, does this conduct have some nexus with the incentives of the new controller? But those are all conceptual incentives of the new controller. And how do you do that? So that is a legal question, actually seems fine. So how do you do that practically? So how do you reason your way through this? And then they say, well, paragraph 66 and 67, in fact, 67 seems to be where they come to the conclusion how you do that practically. They say, on this approach, pre-merger management plans in operation already or proposed may be useful to compare to the plans the firm has post-merger, if available. If the differences are stark, and particularly if the change in plans takes place within a short period of time, then it is reasonable to infer that the post-merger plans of the acquirer reflect a different set of incentives to those of the pre-merger management, and hence can be considered merger specific. So that again is still not a delictual standard of the Bartford test. It is still a unique competition assessment that is focused on the incentives of the new controller, and it is simply asking some nexus, and it's not asking a Bartford question. And that might be helpful on these facts, by the way, Justice Dodson. It might be helpful on these facts. What we know is that the longer the retrenchments are from the merger, the less likely a court will say that these retrenchments are associated with the merger. And then the closer they are to the merger, the more likely that they would be associated with the merger. What we also know is the warning from FAO. FAO says, in our own experiences, although firms tell us that they will not retrench anyone in the bargaining unit, what we know is within 2 years after, they in fact start retrenching. And FAO also says, they always say that there is no connection to the merger. And then they say, well, for these reasons, we want a clear-cut undertaking. And here what they had was a permanent undertaking. It's not one of those where it's 2 years or 3 years post-merger. It's permanent undertaking that you cannot retrench anyone within the bargaining unit. So as a matter of law, we say, well, there's nothing there that's jarring and standing out for criticism. And we say it's also not the same thing as the usual delictual standard of the Bartford test.
Isn't the use of the word incentives in BB to some extent linked with the fact that there was a different scenario there, as I understand it? They were looking at the situation essentially at the time that merger was contemplated and deciding whether or not they should impose a condition and relating to employment. Isn't that scenario one where you will focus far more clearly on what the incentives might be, because you're trying to look into the future? The situation we're dealing with at the moment is one where the events have all taken place, the retrenchments have taken place, and in some ways we're looking in the opposite direction. We're looking backwards. And when we're in our situation, don't you look more carefully at not so much incentives as conduct and decision-making, and the motivation of the decision-making that in fact took place, that did in fact lead to the retrenchments that did in fact take place?
Yes, I think the first question is, what was that case about? I understood that case to have been a complaint by the Commission, in part about whether the merger had already been implemented. So that you will see from paragraph 22 under analysis. That's prior implementation. But yes, it's a prior implementation in the context of the assessment of a merger. Because sometimes what parties do, they conclude the merger and implement it, and then purport to be filing for approval. But that's a technical detail with very little bearing. The real question of substance, as I understand, is this: should we not be looking at what actually happened on the facts? Now, what we know on the facts is what I have tried to show the pleadings say. And there are two questions of fact that you have to look into. One is, was the dismissals in order to remove duplications? And that's the point I've been debating with Justice Rogers. The answer to that is yes. Second point is, were these duplications related to the merger? And I've pointed to 2 paragraphs in the replying affidavit and then to 2 paragraphs in the answering affidavit where the allegations are made. And yes, it's true that there is a denial, but in relation to the link between the duplications and the merger, there are 2 parts where there are admissions. So if you are looking then as what are the facts show, the facts tell us that these were retrenchments intended to remove duplications. The facts tell us that the duplications, at least in part, occurred as a result of the merger. Now, there are obviously extraneous facts that are alleged, but those facts that are alleged are irrelevant for the Commission because it has no jurisdiction to examine the operational justification given by the employer. Its only jurisdiction is to examine whether those operational justifications are linked to the merger. Once it found a connection, that was the end of its function. It then had the rule says must, it then had to issue the notice of apparent breach.
Thank you, Mr. Nkaitobi. Thank you, Chief Justice.
Thank you. Justice Chaskalson. Justice
Thank you, Chief
Chaskalson,
Justice.
you are muted.
I am unmuted. Am I audible?
Yes,
Can
we
people
can
hear me?
hear you. Go ahead.
Mr. Nkaitobi, you were about to come to the argument on jurisdiction when your time ran out. So it wasn't clear to me whether your submission is that the ambit of the tribunal's powers under Rule 39(2)(b) is a constitutional issue or isn't a constitutional issue. Can you clarify that for me, and then maybe I'll ask a follow-up question.
Yes, let me explain what we say in full, Justice Chaskalson. By the way, I am very pleased to refer to Justice Chaskalson.
Thank you very much.
Yes. Let me explain myself in full. What we say about this is that it is true that the interpretation of a rule, such as Rule 39(2)(a), would implicate the Constitution in the broad understanding of what a constitutional issue is. So that is correct. But we argue that it is not in the interest of justice for this court to entertain that question. Why? Because we say that it was admitted by both parties before the tribunal that the issue was a review, and it was a review of the decision of the commission. It was never argued that the commission's decision is irrelevant, which is the argument that has been pressed today. It was never argued that the tribunal performs a function separate and distinct as that of the commission when it examines the issue before it. And it was not argued that this is an issue of reconsideration on new facts, which is the argument we've been confronted with on appeal. So we say on ticket dry, it is not proper for the Constitutional Court to entertain the current argument, which basically says the commission's decision is irrelevant, which also says the commission, in fact, does not make any decision, which also says that the issue is that the commission triggers a process for determination. Those issues have not been decided by the tribunal. They have not been decided by the Competition Appeal Court because of the approach that was taken by both parties, which both parties accepted that they were dealing with a review of the commission's decision. Even in the founding affidavit, it's divided into 3 sections. Section 1 is a review under Rule 39. Section 2 is a review under PAJA. Section 3 is a review under the principle of legality. But all sections are about the review of the decision of the commission. So the point we make is that under the interest of justice standard, you should refuse to entertain this issue as a court of first and last instance.
Thanks. I understand that submission clearly now. Can I take you then to the facts and issues of harmonization? If you go to the FAWU answer at volume 2, page 206, paragraph 119.5, can you go there?
Yes, I am. Just listen.
So, and if you read that paragraph, FAWU, that is how FAWU understands the relationship between harmonization and the retrenchments. And in particular, in the middle of the paragraph, you see, by way of illustration, some bottle washers at the merged entities' bottle operations earned as little as 100 rands per day, while others earned as much as 150 per day. Harmonization would mean that the lower paid bottle washers may have had their wages increased, whilst the highest wage earners' wages could not be decreased. To avoid the financial implications of harmonization under such circumstances, the merged entity resolved to retrench the higher earning wage earners, ostensibly so that harmonization could be implemented in a lower wage environment. Now, that paragraph, as far as I can work out, is not denied by the appellant. What do we make of that then?
Yes, in fact, there are several parts of the foul answer that are just not denied at all. I mean, the part I referred to, 8.4, 8.5, 8.6, 8.7, are also not expressly addressed. The paragraph before, which is 119 and 4 and 119 and 5, are also not expressly addressed. And also the paragraphs at 208, 121.4 is also not expressly addressed in the replying affidavit. So at the very least, we can take it to be that the facts are alleged, and bearing in mind that Coca-Cola accepts that it bears the onus, that it cannot be said that it has discharged the onus for a finding by this court that it has substantially complied. The one thing I wanted to show the court is that summary by FAO comes actually from the Commission's report, which is the report.
Or page 403 to 4, paragraph 15.
Yes.
It's volume 5.
Yes, that's where it comes from. Yes, that's the basis of the FAO report. So it was both the Commission and FAO that made that point.
Thank you. I don't have further questions.
Thank you very much, Justice Chaskalson. I want to make sure that I don't say there are no further indications now when there may be a hand somewhere. Well, it does look like there is no hand. Thank you very much.
It's just a skipper's.
It's just skipper's. Why does it look like they raise the hand just so that counsel can see, but I won't see? Just give us, do you have a question?
Yes, thank you, Chief Justice. Just 2 questions, Mr. Nkaitobi. The first is, could you go to volume 9? And it's at page 832.
Yeah. Yes, Justice Skippers.
And it's paragraphs 93 and 95, which gives the context. It's in paragraph page 832, which gives the context to the statement of the duplications in paragraph 8.1.5, which you'll find on page 833. What do you say about that context? Because I understood Mr. Trengo's argument that the issue of the duplications referred to in paragraph 833 has been wrenched from that context.
Yes. No, it's actually very simple to understand this. What they are saying is that they it's page 833.
Yes.
Sorry, I just want to get to that.
Above line 20.
815. Yes, that's the page. Now, what they say here, it says, we respectfully submit that it is inappropriate in this instance to draw a correlation between such retrenchments, whether attributable to duplication, staff costs, or otherwise, as reasons attributable to the merger in circumstances where these have been occasioned by factors unrelated to the merger. And then they say, as dealt with more fully below, Coca-Cola recognizes that certain of the job losses were occasioned by the removal of duplication, so as to reduce staff costs, and to change the nature of employment within the firm so as to reduce overall costs in view of the unforeseen events post-merger. So the critical part there is the acceptance that these are dismissals in order to remove duplications. And thereafter, the only other question is, are these duplications linked to the merger? And I've already addressed the court why we say that these duplications are linked to the merger. And once you have those two connected, then that's the end of the case.
And one last question, Mr. Nkatobi. What do we make of the facts that the merger was approved some 2 years before the sugar tax was implemented, and Coke could not have known its impact? And I understand your argument based on BB because it's the intention of the new owner, as it were. But what do we make of those facts? Because both CCBA and FABU made submissions on the adverse impact of the sugar tax. And it also does not suggest that it could be a long-intention plan, as suggested by FABU, to retrench because of the merger.
Yes, there are two answers to that proposition that have been given by... Sorry, Justice Keeper, did I interrupt?
Please go ahead.
Yes, all right. There are two answers that have been given by the Commission on the pleadings. Answer one is that an increase in cost doesn't create duplications. I mean, a duplication is the same person doing the same job. So whatever increases in cost, they don't create duplication. A duplication is created by the reorganization of the business. And this is why the Commission has focused on duplications. In other words, same people doing the same job. And that's why it's focused itself on that table 22, and it's focused itself on the page 101 to 106 that show big chunks from regions being removed, performing particular jobs as a result of duplications. That's answer number one that the Commission it has given, that we've got to focus here on duplications, and the duplications are related to the and then number two are the pleadings themselves. You know, that admission by Bowman's, you know, it is not an isolated admission, and one would not excoriate or crucify a lawyer. It's his clients that we say have made the admissions that they were trying to remove the duplications, and then in two places those duplications themselves arose from the by the merger. And I've already given the references to both of those, at least in part occasioned by the merger. So we say once you come to those two conclusions, then it's clear what the Commission was trying to do, and it's clear on what basis the Commission came to that conclusion. But you may then ask yourself, well, what is the standard that you are applying? In other words, is this court performing the function of the tribunal? Or is this court asking itself whether at the time the Commission exercised its power, it acted rationally on the basis of the information before it? Now, our framing of the case has been, you've got to ask the latter question, which is, at the time the Commission acted, it could not be criticized of being irrational or unreasonable or procedurally unfair, which is a proper review, as opposed to asking the question, are we now the adjudicator of fact in a dispute between the Commission and the merging party? That dispute has been resolved when the Commission issued a compliance notice.
Thank you, Chief Justice.
Thank you. I'm looking very carefully.
No, I think finally, Chief Justice, you are right.
Thank you very much, Mr. Ngwaitobi. Thank you. Mr. Trengov?
Thank you, Chief Justice. I propose to focus on two issues. The one is the duplication leg of my learned friend's case, and the other is the harmonization leg of his case. And those are indeed the two legs on which his case stands. And I'll address each of them separately. But before I do, the fact of the matter is that the two legs are irreconcilable with one another. The duplication leg would have it that the reason for the retrenchment was to reduce the overall number of employees because there were duplications created by the merger. So the duplications leg would have it that the purpose was to reduce the number of employees. The harmonization leg, on the other hand, says the opposite. It says you actually hired more than you fired, but you did so to reduce the highest paid the level at which the highest paid employees were remunerated. That has got nothing to do with elimination of duplication. On the contrary, that asserts that you didn't eliminate duplication at all. You just reduced the level at which the best paid employees were paid in order to circumvent harmonization. And my learned friend doesn't explain how he reconciles these two legs of his case, which frankly are irreconcilable. As for the duplication leg, there is actually no evidence whatsoever of duplications caused by the merger in the bargaining level. No evidence, none at all. The Commission manifestly made a mistake on that score. The only basis on which they concluded that there was an elimination of duplications caused by the merger was by reference to its pre-merger report in 2015. But that report itself, not only the submissions by Coca-Cola, the report itself found that no duplications were expected, and that was the very finding on which the Commission later based its case of merger-specific retrenchment. So for my learned friend now to argue that there was some other evidence because FAWU had other suspicions is not the point. The point is that there was no evidence of duplication, and the evidence on which the Commission relied was a mistake, a misunderstanding of its earlier report. And there is now a debate, particularly pursuant to the questions asked by Justice Rogers, whether it is possible that the premise of the debate is that duplications occur only if there is cross-regional duplication, because the possibility of intra-regional duplication was always there. It was not merger-specific. The only additional factor that the merger brought about is the possibility of cross-regional duplication between the various bottling plants. But there's no evidence of that whatsoever. And in fact, the issue is addressed in the CCBA's affidavits. And if I can go back to that little list of mine of the references, where it refers in paragraph 2 to a number of references to the founding affidavit of the CCBA, and in paragraph 3 to its replying affidavit. What all of those paragraphs say and explain is that in the first place, no duplication was expected. And then in the second place, no duplication occurred because all of those bottling operations were maintained. None of them was closed down, and all of them was maintained at full throttle, at full production. So there was no cross-regional duplication. There's no evidence of such duplication, and there's positive evidence to the contrary. And my learned friend speaks of an admission of duplication. There is an admission in a letter which says that one of the reasons for the merger was to eliminate duplication. But it doesn't suggest for a moment that that was merger-specific duplication. On the contrary, it occurs in a paragraph which asserts that none of the retrenchments were merger-specific. So at the high water mark for my learned friend's evidence is an admission that there was some duplication eliminated by retrenchments. But it doesn't begin to suggest that that duplication was caused by the merger. It was caused by the downturn in the economy, the downturn in the demand for the product, for the Coke product, and therefore the redundancy of some of its staff because of the lower volumes that they produced and distributed. And we submit with respect that there is no evidence of retrenchments caused by merger-specific duplication. As for harmonization, can I first say two things? Firstly, particularly in response to some of the questions Justice Shaskelson asked me. Justice Shaskelson, my side has looked, and we're not aware on record of a second suspected breach, apparent breach notice. And all the indications are that there is only one. And let me say, the apparent breach notice on which the case was heard in the tribunal is the one at page 122. That's the notice of 24 October 2018. And that notice is avowedly limited to the one complaint, and that is, it refers back to the pre-merger report, and it says, as that pre-merger report predicted duplication within the bargaining unit, that duplication has now occurred. That was the only case made in that apparent breach notice. And that was followed up on 29 April 2020 by a further letter from the Commission at page 148. And that letter...
1 minute left, Pengov. You have 1 minute left.
Thank you, Chief Justice. That letter again explained that the original notice is the only one pursued at that point. Lastly, there is the evidence, the point made by Justice Rogers, the evidence gathered in the founding affidavits. Now, if I can just give you the references, the founding affidavit in the tribunal, page 17, paragraph 48, the Bowman's refers to and incorporates the Bowman's letter at page 145, paragraph 5. And then finally, the founding affidavit in this court, page 835, paragraphs 97 to 103. And all of them make this point that if harmonization had been the motive, we would have retrenched all the highly paid employees. Instead, those who were retrenched were by and large the less well-paid employees, and therefore there was no harmonization motive at all.
Thank you. Thank you, Mr. Trengov. Justice Chaskarzan?
Thank you, Chief Justice. Mr. Trengov, if your primary submission is correct, that this was not an issue that you were called upon to meet or to deal with head on, does it not follow that at the very least the declaration of substantive compliance by the tribunal has to be set aside? Because it's one thing to set aside, for the tribunal to say that this complaint wasn't well-founded, we set aside the notice of apparent breach. It's another to give you what would amount to a get-out-of-jail-free card on all issues with an unqualified declaration of compliance, which is what we see in the tribunal judgment at volume 8, page 740, paragraph 90 of the judgment, paragraph A of the order.
With respect, one needs to first determine what the issues are that are legitimately before the tribunal. Those issues are a particular complaint of non-compliance, a notice of apparent breach in one respect. And then the rule calls upon the company, the suspect, to demonstrate that the firm has substantially complied. I submit with respect that it means in the context of that rule that it is not guilty of the crime of which it has been accused. There is no onus on it to exclude all other possibilities of non-compliance over and above the charge made against it. So I submit with respect that to make sense of the rule, the firm is entitled to an acquittal if it can show that it's not guilty of the offense charged by the Commission. It is not incumbent on the firm to show that it is also not guilty of any other possible contravention. And add to that the point that I've conceded to you earlier, that it's probably open to the Commission if it wishes to pursue a different complaint, to come again.
But it's in that respect that it seems to me that paragraph A of the order goes too far. Because if the commission were to come back tomorrow to say, well, we've now looked at the facts again, we're of the view that there was a breach of 9.2 of the merger conditions, because part of what motivated these retrenchments was the need to get the retrenchments in before the deadline for harmonization. They should be entitled to do that, but paragraph A on its face would prevent them from doing that.
If you regard paragraph A to render the commission fictus officio, I accept that the order made by the tribunal, properly interpreted, shouldn't go further than to say that the firm is not guilty of the transgressions of which it has been accused. But that would ordinarily be the implication of any order that is made.
But isn't that, it doesn't B make that clear on its own? B says setting aside the notice of apparent breach issued by the Commission on 24 October 2019.
No, with respect, we're entitled to a positive order. We've shown that we're innocent of the complaint made against us. And if you want to make that a general acquittal of all transgressions or an acquittal of this particular one, we are entitled to an acquittal.
Thanks.
Thank you. I am careful again. I don't see any indications. Thank you very much, Mr. Trengove.
Thank you, Chief Justice.
I don't see any indications for further questions from my colleagues. Thank you very much, and we thank counsel on both sides for their submissions. We will take time to consider the matter, and once we are ready, parties will be notified about the judgment being handed down. In the meantime, judgment is reserved and the court adjourns.
Thank you, Chief Justice.
Today's proceedings have concluded. The host will now terminate the meeting.